Item number 20.
So this is that fire service PI.
Yes. Yes.
Sir, in preparation for today's appearance, we have taken stock of the situation. The situation is we had meetings also with the health secretary and the chief engineer of the works department. All the administrative approvals which are pending with the health department will be cleared today. Some have been already cleared. Nine are left, they'll be cleared. And the chief engineer has assured that tender process will start within a week. We have divided, in our recommendation to the SCB authorities and the PWD, to divide the works to be taken into 3 categories. What is to be done within 3 months, what is to be done within 6 months, and what is to be done in the long run. For example, within 3 months, we have asked them to locate more fire extinguishers, give exit signages, public address system, lightning arrestor. 6 months, we have asked them to provide underground static tanks, terrace tanks, etc. There's a list which is available, which we can share exactly what we are planning to do. In the long run, we have suggested, we have asked them not to locate any facility with ICUs or more than 30 beds in the old structure. And if some structures cannot be demolished because the hospital is under renovation and a huge project is going on, then they have to provide a second staircase and a fire lift. So we have given our recommendation and there's a summary. As regards the different buildings and what is the requirement, we have arranged it in a tabular form. What currently exists, we have taken stock of the inventory, and what needs to be done in respect of the 85, we have given a list. Currently, we have a fire station in operation since 2016. So we have 14 people there. We have a fire engine also there. We have attended since 2016, 85 small incidents, but we would be able to handle till that time. And we expect that within the next 6 months, the SCB authorities will comply all the requirements.
SCB is the name of the
Medical college.
Can you share that?
My lord, we have 2 copies, but it is not under a memo, if your lordships don't mind. My lord, my apologies.
So, can you provide us a soft copy of this
Yes.
so that we can incorporate everything in our order?
Lordships had said it will be monitored on a.
Therefore,
Where?
For each activity, we have given a timeline. If your lordship looks at Annexa 2,
Next page.
the next page. We have said what is to be done within 3 months in the last column. What is to be done within 6 months. We have had elaborate meeting with the health department, the director of medical education, the works department, and the state government is fully cognizant of it, and we will comply everything. They have assured that they will comply, and we will recommend and monitor.
and in the beginning you said that some certain like approvals or
Yes, in the last hearing, the superintendent engineer had said that administrative approval is awaiting.
yes.
So I had a meeting with the health secretary, and all the administrative approvals have been accorded -9.
Administrative
14.
approvals for
For construction of the building, because once they prepare a plan and estimate, they have to be approved by the concerned department because they have to provide funds. We have already cleared there are 62 tender processes have already started, 14 are pending. These 14 are above 75 lakhs. So they have gone to the finance department.
Two tender processes are for what?
For in the different buildings, they have to take up changes that we require them to take up. They have to engage a contractor.
Modifications to the building is necessary. Modifications to the building is necessary.
Yes, modifications in the sense, at some places, they have to provide water sources. They have to install a fire pump. They have to provide sprinklers. That will take a little time. But the activities that we have earmarked to be completed within 3 months, like buying more fire extinguishers, putting fireballs, they can be done within 3 months.
62 applicants have been happened and 14 are left.
14 are left, 62 tender process has started. And the chief engineer-
Installation takes some time.
installation of the fire alarm or fire smoke detector, they would be within 3 months.
Hmm.
But where we have to do construction activities, it would take 6 months.
What is your designation and name? Oh. Yes,
My-
something is being done, Mr. Shyam.
I want to submit something, my lord, if
What?
your lordship permits. That this matter relates to fire safety system, and your lordship has been pleased to direct the DG and to appear in person and submit. They have already submitted. Now my submission before your lordship is that the administrative approval has not yet been done. The
Understood.
allotment of funds has also not been done as it appears. And that besides, my lord, main problem is that until and unless the patients who are now in the hospital will not be shifted, the construction work cannot be done. They have stated. For that reasons, what they have steps have been taken that has not been stated.
So please appreciate
My
two
lord.
things.
My lord,
That we are not in adversarial litigation,
my lord,
and secondly, they are also equally concerned.
my lord,
We are just here to facilitate what is
my lord,
happening.
my lord,
All right.
my lord.
So we all of us, you, the Director General, the Advocate General, and the court also,
My lord.
we all are making efforts to ensure that the fire safety measures are available there.
My lord.
All right. So let us see, and therefore the court has taken up the matter very seriously.
My lord.
There cannot be, we cannot use any magic
My lord.
that from tomorrow everything should be installed or everything should be
No,
there in place.
No, my lord. I am only to submit.
Yes,
Is also very old.
and we are very happy
My
the
lord,
way the Director General has presented the report,
my lord.
the things which have been done in the meanwhile after the order was passed, we would be expressing our satisfaction.
My
We
lord.
appreciate that.
My lord, we are absolutely for your lordship interference only that's been done, my lord.
Therefore, they have understood the seriousness.
My
And,
lord.
all right.
Grateful.
My lord, next date will be
Next day we will
my lord,
let us decide the next day.
my lord. Oblige.
Uh, in the light of this court's order dated Four 2024, Mr. Sudhanshu Sarangi, the Director General Fire and Emergency, Commandant General Home Guards, and Director Civil Defense, Odisha, is personally present.
Lord, may I say, the lordships had also asked the superintendent engineer and medical superintendent to be present. They are also here.
Full stop. With him, So and so please with him. Further, Mr. Pravas Kumar Manji,
Yes, madam.
Superintending Engineer, Katak, bracketed R&B, Division 1, comma, Sudhanshu S. Misra, Medical Superintendent, SCB Medical College and Hospital, Katak, Odisha, and Trilok Babu, Trilok Babu, Fire Officer, Central Range, CTC are also present. So stop. The Mr. Sudhanshu Sarangi, the Director General, Fire and Emergency Services, has presented before us uh, a summary of building details of the SCB, MC and H, full form of the hospital, comma, Katak, and the suggested fire safety measures with the time frame to accomplish such measures. Full stop. As we have decided to monitor the progress of installation of firefighting systems in the medical college, as is reflected from the order dated 4/3/2024, we deem it proper to reproduce the details which have been submitted by the Director General Fire Services. Give us soft
We
copy.
will give it.
Full stop. He has informed this court that administrative approvals
My lord.
have been granted by the competent authorities at various levels, and tender processes have begun
Your Lordship is right.
For
62, madam.
62,000.
Yes. According.
Hmm?
According improvements.
Tell me.
Inform this board that adequate approval of an example of the complaint of the issue and whether it's
The various levels for installation of equipment and making structural changes as and where required in the building, so as to ensure that the firefighting system in the hospital is effective. First off, he has further informed that administrative approval is awaited
Lordship, in respect of 14
in respect of 14
works,
constructions or what?
14 projects.
14 projects. What is your expectation?
Within a week.
which is likely to be cleared within a week. Full stop. Next. We do appreciate the efforts made by the Directorate of Fire and Emergency Services, that is Directorate of Fire Emergency Services, and other officials of the state for having taken up the issue of having effective firefighting system in the hospital seriously, seriously, as is reflected from the summary which has been submitted by the Director General and has been reproduced herein above. So stop. The court expects that the authorities at various levels shall ensure that 14 projects which are awaiting that administrative approval, that the grant of administrative approval in respect of rest of the 14 projects shall be expedited. So stop. List this matter on 4 weeks. So stop. On the next date, the court would expect the Director General Fire Services to file an affidavit, Fire and Emergency Services to file an affidavit. Give more time, 8 weeks. 8 weeks.
Why not?
List this matter. List this matter on 8 weeks. Stop. Let an affidavit be filed by the Director General and Director General Fire and Emergency Services by the next date, detailing the progress in the meanwhile. Top. Personal attendance of the officials shall not be required on the next date.
So let him come.
All right.
Let him come. It's
It will be-
better for your lordship to
All
communicate.
right, all right. The court would appreciate if on the next date, the Director General Fire Services, Fire and Emergency Services is present to assist this court.
Grateful.
Madam, a copy of the affidavit may be sought to us.
You
So
will
that I
get-
can take state.
Please give me.
Yes. The affidavit and this document also will share with you.
Mr. Mani,
This
entire document is getting into the
Part of
order,
the
part
This
of
is
the
there
order.
in the order, so you will get everything in the order.
Order, I will get that, but the affidavit which is going to be filed by
We will get the-
that copy must be
That
served.
in due course.
It will be served. Obliged.
In fact, we are preparing a writ petition for you by incorporating everything in the order.
I am obliged, my lord. Only because your lordship's interference, this progress has been made,
Progress will be made.
my lord.
It's a very old structure. That structure has to be modified with care and caution.
It will take some time. Already, the lordship has already interfered and monitoring, so that we are very much obliged, my lord.
Press admission item number 1.
Please, my lords. Public interest litigation, my lords. Find that the instance of my lords villagers of 29
PIL.
villages. I'm sorry, my lords.
PIL.
My lords, PIL. At the instance of 29 villages, my lords, praying that the settlement operations in their area may be continued in accordance with the, my lords, directives of the state government at Annexure 2, my lords. The background is this, my lords. These 29 villages were initially notified that for the their lands were demarcated and my lords, settlement operations were stopped. On the my lords, plea that second steel plant would be set up in that area, Jajpur area. Now, in course of years, it was stopped. In course of time, my lords, the government shifted its focus to another area, and the steel plant eventually came to be set up in that other area adjacent close by. So therefore, these lands are no longer required. Accordingly, my lords, in page 17, the my lords, Director Land Records and Survey and Consolidation Rights passes an order that now that it is not required, that your lordship finds at page 17, he passes an order that now that this is not required, the settlement operations can proceed, one, and immediately those files may be forwarded to the government to denotify the area. Then, my lords, despite that, my lords, nothing happened. So therefore, a writ petition was filed, a PIL was filed earlier, wherein, my lords, during the pendency, that order of the PIL was, your lordship finds at page 41. During the pendency of the PIL, my lords, the government comes up with a notification dated, my lords, 24th May 2022, that your lordship finds at page 25. In exercise of the powers, if your lordship permits
Yes,
me,
please,
my
please.
lords, in exercise of the powers conferred under subsection 1 of section 3 of the Orissa Survey Settlement Act 2012, read with 12(1) and Rule 4 of the Orissa Survey Settlement Rules, the state government do hereby notify 204 villages of Jagat Singhpur, Jajpur, Kendrapada, Kalahandi district as scheduled for conduct of special survey and settlement. In view of this, my lords, your lordships disposed of at page 41 directing that the notification dated 24/5/2022 be worked out within a period of four months from, my lords, 28/6/2022. My lords, unfortunately, nothing has been done till date to work out the order. As a result of which, my lords, we are unable to transact lands. Land documents are not being able to prepare. Nothing can be sold. Nothing can be bought. My lords, people who are in need of money to even sell the land to, my lords, for any medical need or, my lords, other needs, they are unable to proceed. So I was only praying that the
So
government.
who wants to sell?
No. Some of them, my lords.
Who?
In general, my lords, in general, there's no specifics, but this is the general requirement in the area. My lords, in any event, my lords, settlement has to take place. As per the notification of the state government, the settlement operations have to proceed. Otherwise, my lords, the lands cannot be transacted. And the records, people have died in the meantime. Their, my lords, legal ads have to be substituted. Then, my lords, so these are.
I have to take instruction because there is this notification of 2022. Pursuant due to this notification, they must have started the settlement operation. And so far as the allegation of the petitioner that transactions are prohibited, I think by virtue of old records also, these sell deeds can be
So the
executed.
market rates, nothing has been,
So, but still then they have to
there are difficulties.
work out this notification as per the order of this honorable court. So let me take instruction on this.
Have you served?
But
Yes,
I've served a copy on my learned friend.
8 weeks' time is allowed for the estate to file its mounting affidavit. This is matter on 8 weeks.
Great.
Item number 2. Please, your lordship.
Granted 2 weeks time. In the meantime, I'll find out whether the order has been complied or not, or instruction was in the stage of.
Page 18 is the order which is to be, need to be carried out by the collector. As my friend 2 weeks, because this order was passed way back in 2023 and granting 4 weeks time to comply with the order. Till date, nothing has happened. And I have duly communicated the order of this honorable court along with all supporting documents.
We will take up the matter at 2 p.m.
This matter.
In the meanwhile, you seek instructions. Treat it so casual.
Right, no. As well as please.
At 2, come at.
Item number 3.
So item number 3, lordships this honorable court were pleased to grant me not time on 3 occasions regarding compliance, because we have approached the honorable Supreme Court, there we have lost lots. The Supreme Court last 1 year, the Supreme Court has passed that order. I am saying that we have lost to what else? We have lost in the
Last
Supreme Court.
1 year.
And do we want to comply the order? Lordships were pleased to grant me time. They are in the process. Because lordships, week's time, lords, we can do it. What is the stage they have set, me lords.
3 times, my lords, they have taken.
3 times.
They have taken 3 times.
3 times.
Yes, lords. I've said that lordships were pleased to grant me 3 occasions, lords, time to comply the order.
Who has to comply with you?
No, sir.
That is, one will have to go, the secretary.
Who?
The secretary, additional chief secretary to government department of water resources.
Where is the order?
That is directed to opposite, but annexure 1, my lords. Annexure 1, my lord, that is at the page 11 of the operative portion is the page 11, my lords. The last 4 lines, my lords, that opposite, consequently, the opposite parties are directed to regularize the service of the petitioner. Page 11, my lords. And extend all consequential benefits as due and admissible to him in accordance with law within a period of 4 months from the date of communication. Which has been affirmed, my lords, and by the Honorable Supreme Court, my lords, on 24/2/2023.
And when was the SLP dismissed?
On 24/2/2023, annexure 2, my lord, at page 12.
It's a deliberate. Nodal officer to ensure that the orders of the High Court are complied with.
Keeping tab over
Yes.
outcome of SLP,
Yes.
is there any nodal officer? apart
There's
from-
no single nodal officer, but in respect of all the administrative departments, there is a law officer, my lords, who looks after all the affairs of this notes courts, my lords.
So they are also to be hauled up.
In fact, we contact all the courts, my lords, compliance, we contact with them only, whether it has been complied, thereafter we talk to the authorities, my lords.
Well, let us initiate contempt proceeding in this.
Many
Contempt.
cases nowadays, it is coming forth that after SLP, no further step is taken to comply with our orders.
Right, my lords. In 34
Many
cases,
cases you have seen.
34 cases, pursuant to laws to indulgence only could comply, my lords, even after losing in the Supreme Court, same department, my lords. This is one of them, my lords. 34 cases we have complied in the meantime, my lords. This is another similar type of case, my lords.
All right. Let there be some action in one of the cases. This is one.
Or may I pray, my lords, will also be taking up that other matter 2 p.m. This also will also may take up 2 p.m. I will also obtain instruction. If not, also you can pass that order, my lords. I will not stand on the.
2 p.m. we will
Yes, my lords.
initiate contempt proceeding.
Item number 4. The pleasure of my lord. So the writ appeal, my lord, filed against the judgment of the honorable single judge, and where, my lords, the fresh evidence has been appreciated and concurrent findings of the 3 authorities below, my lord.
Where is the order?
My lords, let's me annexer 1 at page, my lords, 32. Let's me see page 32. I had also preferred on review, my lords. In the review, my lords,
Where is the order?
my lords, page 32, lordship.
Page 30.
Annexer 2, my lords. Page 32 starting, my lords, is operating position start 34, my lords. Lordship
Yeah.
got, my lords.
What is wrong in the order?
Lords may kindly see, lords. The fresh inquiry has been taken by adding fresh parties in the writ petitions, my lords, under 222.
What are the facts? Sir, just quickly say.
Fact is, my lords, one certificate, resident certificate issued by the competent authority, my lord Tahsildar, was challenged in appeal, my lords, in supplemental. Supplemental also confirmed the order of the Tahsildar, my lords. Earlier to that, my lords, the opposite party of 6 has approached this honorable court. In 2006, my lord, this honorable court directed to the collector to make an inquiry and find out the position of the certificate as well as the, my lords, employment of the petitioner, this appellant, my lords. Pursuant to the order of this honorable court, my lords, inquiry has been made by the collector and it has found that certificate is correct and correctly issued and she has been appointed by the competent authority correctly, my lords. That is also been a part of the annexure, my lords. Thereafter, my lords, the opposite party number 6 challenged the certificate without challenging the order of the collector, my lords, challenged only certificate issued by the Tahsildar. That certificate, my lords, was again confirmed by the Tahsildar.
Certificate regarding what?
Certificate regarding the residence, my lords, proof of residence, my lords, which is one of the criteria for applying the Anganwadi workers, my lords. That has been confirmed by the Tahsildar, my lords. Again, that appeal came to the sub-collector, that was also confirmed, my lords, by the sub-collector, my lords. So 3 authorities below, my lords, starting from collectors, Tahsildar and sub-collectors, they found that taking 9 documents, my lords, as well as the evidence, local inquiry by the RI and the Sarpanch who has adduced evidence for the collector, also they found that this is correct. Then the final order of the sub-collector was challenged by the opposite party 6 in a writ petitions before the honorable single judge, my lords. The honorable single judge, my lords, added one party, suo motu, and my lords started fresh inquiry on the document whether the this appellant belongs to that area or not. Inquiry was made directing the electricity department to take a satellite view of that positions, my lords. And satellite view was taken longitude, latitude, and that was found that is from other village. That is electricity belonging to my father-in-law, my lords. Whereas my birth certificate to my daughter, my lords, belong to my area. My husband's, my lords, the DL, my husband's school living certificates, all have been, my lords, ignored. Only electricity was taken, my lords, and they are added in new party in this writ application 220, which is, my lords, according to me, and there are category of judgments, my lords, the fresh evidence cannot be appraised or reappreciated by the honorable single judge, my lords. I have quoted all the judgments, my lords. So only I pray, my lords, stay of the impugned order, otherwise they will terminate me, my lords.
That will be subject to.
The status quo may be considered, my lords, by so I am continuing in my service, my lords. That
All right, let us see. Let them.
status quo may be considered, my lords.
Both
Sir.
Speed post. Requisites 1 week. We will see later.
Ma'am.
Much obliged.
Item number 5.
May I please, Your Lordship? Your Lordship, in this writ appeal, the order dated 10/4/2023 of the learned single judge has been challenged. Wherein, Your Lordship, the fact of the case is that the writ petitioner was,
Where is the order?
Your Lordship, page 18, Annexure 1. If I may place the facts, Your Lordship.
Please, please.
Your Lordship, the fact of the case is that the writ petitioner had applied for the post of Assistant Section Officer in the year 2016. Thereafter, Your Lordship, he was selected. Your Lordship,
Just this is writ appeal 17 or what?
writ appeal 148.
Just a minute. I have opened a wrong case. 148.
Yes, Your Lordship.
Page 17 is to be ignored.
It's a clerical error, Your Lordship.
Yes, you are challenging this order.
Yes, Your
10/4/2023.
Yes, Your Lordship. Lordship, the writ petitioner before the learned single bench, Your Lordship, he was selected for the post of Assistant Section Officer, and I was also the candidate, Your Lordship. We were both ST candidates, and the fact of the case is that, Your Lordship, he purported himself to be a sports person and could obtain extra weightage, as a result of which he was granted the selection, Your Lordship. Your Lordship, against this selection of 2016, a batch of cases were filed in front of the tribunal, Your Lordship, and thereafter an order was given, a direction was given to review the entire process. After reviewing, he was removed, and another 10 candidates were shortlisted for skill test. I was also one of them, Your Lordship. Thereafter, I approached this honorable court whenever my result was not published. Thereafter, a direction was given to the authorities to look into my matter. As a result, I obtained a letter from the authorities, which I have annexed, in which they said that since the writ petitioner had purported himself to be a sports person, he was placed in the first rank. However, later it was realized, it was seen that another person had scored more marks than him. I have also scored more marks than him, Your Lordship, and hence that other person was given the post. So I remained satisfied, Your Lordship, since I had scored less than the other person, Your Lordship.
There was only one post. How many posts?
One post, Your Lordship. And since I had scored less than that person, I remained satisfied, Your Lordship. Thereafter, it came to my knowledge that the writ petitioner had filed this writ petition and had obtained a stay by totally misrepresenting the facts and completely suppressing the fact that, in fact, he had purported himself to be a sports person, Your Lordship. In fact, if Your Lordship gives a glance to the entire order, that fact has never been brought into record, Your Lordship, neither by the writ petitioner nor by
No,
the
but there was only one post advertised.
No, Your Lordship, the advertisement was for
All right.
one ST post.
The dispute is in relation to one post.
One post, Your Lordship.
So that post has been filled up.
Your Lordship. Thereafter, by this order.
No, that post has been filled up.
Yes, Your Lordship.
That post has been filled up by a person who is more meritorious than you.
Your Lordship, that person was given on a vacant post, Your Lordship. the writ petitioner still continues in the same post. Only due to the stay order that he had
You
obtained.
were not the writ petitioner.
No, your lordship.
You were the opposite party.
I was not made the opposite party, your lordship. I am a third person who's an aggrieved party, your lordship, since I have scored more marks than the writ
And you,
petitioner.
you cannot challenge the order. You could have, there is a direct judgment of Supreme Court. If you were not made a party and the order is against you, then you can seek recall of that order.
Your lordship, I had,
Huh.
and that was rejected, your lordship.
That has been rejected.
Yes, after
Review-
that, your lordship.
Review is at your behest.
Yes, your lordship, review was rejected. On this very ground, I had filed for the recall of the order, and thereafter I am seeking appeal, your lordship.
Where is the review order?
Page 98.
Yes, your lordship. Page 96, annexure 5, your lordship.
According to you, someone is working against a post who is less meritorious than you.
Yes,
This is your grievance.
Yes, your lordship.
This is the only grievance.
Yes, your lordship.
Because of his sports
Yes,
weightage.
your lordship, which he did not produce, which has been admitted by the department themselves, your lordship. And your lordship, this order, if your lordship sees the impugned order, the judgment that the single judge has relied on says that whenever there is no fault of the petitioner and he has been given selection, thereafter he cannot be removed. Had this fact brought into record, your lordship?
Take us to that aspect where department has accepted that that certificate was not produced.
Yes, your lordship. It's in page
Count-
75, your lordship.
In the counter affidavit.
In my, it was, I had annexed in my review petition, your lordship.
Page
75. Page 75, last paragraph, your lordship.
besides.
Yes, your lordship. Besides, it is seen that Dinobandhu Munda, the last.
Just one. Yes.
Besides, it is seen that Dinobandhu Munda, the last ST candidate whose name found place in the select list, was called for skill test as a ST male sports person who failed to furnish the required sports certificate. Since no other ST male candidates were available out of the candidates called for skill test, his name found place in the said select list.
This is a departmental letter.
Yes, your lordship.
Right.
It was furnished to me by in pursuance to the order of this honorable court.
OPSC.
Yes, your
OPSC
lordship.
has stated this.
Yes, your lordship. Obliged, your lordship.
Speed post. 2 weeks. IAN.
In I,
I will take notice for opposite.
OPSC also you are appearing?
No. I will take notice.
OPSC different council.
Yes. I will take notice for opposite partner 1 and 2.
AGA accepts notice on behalf of opposite parties. Respondent or opposite?
Respondent, my lord.
Respondent
1 and 2.
1 and 2.
Item number 6. May I please your lordship?
You have filed why is this delay shown?
Is there any delay?
No.
Your lordship, I was
Yes,
diligent.
Sir has said 2 days delay, but bracket no delay.
No delay.
Bracketed no delay. -2. I thought that is 2 days delay.
Item number 6. May I please your lordship? My lord, I have filed this writ appeal.
This is 259. Is this 259?
My lord,
Yes.
My lord, I have filed this writ application against the order of the Honorable Single Judge of WPC number 40243 of 2023. My lord, in this case, the appellant is the Bhendi of the RST. Bhendi of the RST, which has been executed on 18th
Bhendi
of, my lord,
Vendi of what?
Bhendi means he is the
Vendi of what?
Bhendi of the RST, registered sale deed.
In a registered sale deed, he is the purchaser.
Nominee has
He is the purchaser.
He is the purchaser.
VORSD, you can say.
Bhendi. And Bhendi is the seller and Bhendi is the purchaser.
Yes,
My lord,
that meaning of the word I know. But this abbreviation I was not.
RSD.
RST.
RSD, registered sale deed.
All right.
My lord, this draft deed was submitted on 18th August 2023 before the sub-register Mahanga opposite party number 5. And it is duly verified and registered has been done. He has registered the deed. And after that, after 10 days, he, according to Annexure 4 of the writ petition, page 14, he has rejected that deed on the ground that one of the vendor was a minor at the time of registration. My lord, my humble submission before your lordship that Annexure 11 of Annexure 2, page 11 of the writ petition, that vendor who was declared as minor on the basis of the legal heir certificate issued by the Tahsildar. At that time, he was 10 years old prior to in the year 14. In the year 14, that legal heir certificate was issued by the concerned Tahsildar, and at that time, that vendor was 10 years old according to the statement of the Tahsildar. And at the time of registration, she reached at the age of 20. And the draft deed was completed. It was submitted before the sub-register and it was also registered. And the ticket is also issued to the Bhendi, Bhendi to receive the sale deed. But after 10 days, again that appellant, Bhendi, received a letter, the rejection letter from.
What was the, when had you submitted your documents for registration? When were the documents presented for registration?
My lord, I have submitted it before the sub-register. And
when?
On 18th August 2023.
So on that day, Lipsa was not a minor.
My lord, according to legal heir certificate, he was not minor. But afterwards, it is detected that he is minor. It is detected by the sub-register that he is minor.
So on what basis did he reject that she was a minor?
On the basis of her own declaration in the sale deed itself.
My lord, no, in the sale deed on the basis of that legal heir certificate.
And you can present another document for registration. You can file another document for it. It was mentioned in the deed itself that she was a minor.
My lord, actually she is not minor at that time.
Actually will not do. What is mentioned in the registered in the deed is important.
My lord, already it has been registered.
What is this annexure 4 before the writ 4?
My lord, for with the rejected a letter, rejection letter of the sub-register.
You have not made it forming part of this writ appeal.
My lord,
You have not made that document a part of this writ appeal.
I have filed it in the REIT WPC. I have filed it. I have annexed all the documents.
Learned single judge has put emphasis on that, saying that it further appears that the vendors have not approached this court assailing the communication under Annexure 4.
My lord,
That is a vital document.
my lord,
That is the impugned document.
Impugned
before the
document.
honorable.
my lord,
Sir, Learned single judge has said that they have not challenged it.
The vendors have not challenged, the
Vendors.
vendors have challenged. That is the view of the vendors should have been the petitioner before the honorable.
my lord, my REIT petition has been rejected only two grounds. One is the petitioner has no locus standi to file the writ. Point one. Point two, on the basis of minority.
No.
On the basis of the basing on these two grounds,
We are not inclined to interfere. The appellant has put to challenge an order dated 3/1/2023 passed by a learned single judge of this court in WPC number 40243 of 2023, whereby the appellant's writ petition filed under Article 226 of the Constitution has been rejected. Stop. Short facts of the case, which are not in dispute are that sale deed was executed in favor of the appellant by the vendors, which was sought to be registered. First off, the sale deed was presented for registration before respond number 5. Respond number 5. Full stop. It was noticed by respond number 5 that one of the vendors, namely Lipsa Sarkar, was a minor at the time of execution of the sale deed. Full stop. He accordingly refused to register the same on the ground that permission of the competent court was not appended to the sale deed. Next, and counsel appearing on behalf of the
my lord, may I submit another thing? My lord, there are 7 vendors, and except this, others are they are lawful vendors. But as per Minority and Guardianship Act, my lord, may I read section 6? Natural guardian of a Hindu minor. The natural guardians of a Hindu minor in respect of the minor's person as well as in respect of the minor's property, excluding his or her undivided interest. My lord, it is a joint family property. She may be minor or major, but other 6 vendors, they are lawful vendors. They are lawful vendors. Now they are going to lose their, and already they have received the consideration amount. All the vendors have received the consideration amount, and I am the vendee. Now they are not in a position, all the 7 vendors, they are not in a position to assemble and execute another deed. My lord, that is a joint family property. That is not, she is not the sole owner. It is applicable only if she will be the sole owner. But in this case, this is a joint family property. And her mother also executed the deed. Her mother, the legal guardian, her mother, after the death of his father, mother and daughters, there are 2 legal heirs of that deceased. And mother herself, she has executed with her daughter. Her share only that Lipsa may be minor or major. But other sellers, other vendors, they are lawful sellers. So now they are in different places. It is not possible on my part to assemble all the 7 members for a new execution. So, my lord, already I have completely given the consideration amount and they have taken away. If that deed will be declared as rejected, so I will sustain an irreparable loss. My lord, if she is minor, for the sake of argument, if she is minor, his share, but what is the problem in registration? My humble submission before your lordship, what is the problem in registration? And the sub-register is not competent to reject the deed. He may refuse under section 22, but he cannot reject the deed after registration. This is the matter of civil code.
So now do we have permission to complete our order?
Mine.
We have this permission. So will you again interject?
My lord.
Will you again do that? Do we have your kind permission to dictate the order?
Sorry, my lord. Sorry.
On behalf of the appellant has firstly submitted that the SID vendor, that is Lipsa Sarkar, namely Lipsa Sarkar, was in fact a major on the date when the document was presented for registration. First off, he secondly submits that admittedly the rest of the vendors whose names figure in the sale deed were major and therefore major, full stop. Mother of Lipsa Sarkar is also one of the vendors. Full stop. He accordingly submits that the registrar, that the sub-registrar committed an illegality in issuing a communication declining to register the document, which aspect has not been duly considered by the learned single judge. So stop. Next. The fact is not in dispute that one of the vendors whose name figured in the sale deed was a minor. So stop. She did not have the capacity to register the sale deed. So stop. Referring to the provision under Hindu Minority and Guardianship Act, read with the provisions of the Guardian and Wards Act for alienation of property, then single judge has taken a view that since no permission was appended to the sale deed presented for registration, the sub-registrar has rightly communicated to the vendors that the deed could not be registered. So stop. Next, we do not find any legal infirmity in the order passed by the learned single judge requiring interference by this court in an intra-court appeal. We do not find any merit in this appeal, which is accordingly dismissed.
Item 7.
Lordships, item 7, I'm appearing for the appellant. Lordships, may I kindly be permitted to appear online?
Please do.
Lordships,
You are appearing for the appellant.
I'm appearing for the appellant, Lordships. And on the
Just a minute. State Council has to say something.
Please.
My lord, on 13/3/24, though, on 6/3/24, the my lords have not reflected, but my lords wanted me to to take instruction on the order passed on the basis of the honorable single judge. What order? May not be taken up on Friday. I will produce the order.
Can we post this matter for Friday?
Please, Lordship.
Madam,
Please, Lordships.
Learned AGA has sought adjournment for which is Friday. Date as requested, list this matter on Friday.
Item number 8.
Obliged, Lordship.
My lord, on behalf of my senior Mr. S.K. Rai, I am pleased your lordship. This petition has been filed by challenging the inaction of the opposite party in not paying the compensation amount. Previously, one contempt petition was filed before your lordship and was disposed of.
This is item number 8.
Item number 8, ma'am.
8 is contempt case.
Yes, ma'am.
Yeah,
Earlier contempt was disposed of on 3rd October 2023.
Yes, yes.
You have quoted it page 12
Page
of
5.
your representation or the authority has stated.
Yes.
So this is contempt case.
Yes.
Violation of which order?
Violation of order dated 3/10/2023.
3/10/2023.
Arising out of
Say, Mr. Pursuant to order in contempt by this court on 3rd October 2023, the Special Land Acquisition Officer has disposed of your petition. He has complied with that order.
Because officers were present in the court. The NTPC authorities were directed to deposit the amount. They deposited because collector wanted 2 crore some odd should be deposited. They've deposited. If you also come to page 12, the LO Convol has observed, paragraph 3, page 12, in compliance of the order dated 27/9/2023, Mr. B.K. Pandey, General Manager NTPC Konya appears in person, stated that he has already complied with the order passed by this court by depositing the entire amount of rupees before the collector on board towards compensation amount as per the such and such. In view of the effect, you are hereby requested to submit fresh land acquisition proposal as per along with administrative approval to the office of taking further action. The above noted instruction is a guideline for the how it is contemptuous, I don't understand. It's a letter of the land acquisition of
last para.
Mister, where is the order of this court? You are alleging violation of this court's order. No. Is it your case that some order of this court has been violated? Are we not clear?
Till date, no compensation has been made, ma'am.
The compensation was to be made under the order of the court. Okay. Let us see your contempt petition.
From your prayer, as it emanates, you want 2/8/2016 order to be implemented.
Yeah,
So it is beyond time now. If you say prayer,
there is nothing. In the present contempt application filed in 2024, the petitioner has alleged violation of an order dated 2/8/2016 passed in WPC number 8430 of 2013 and a subsequent order dated 3/10/2023 passed in CONTC number 1352 of 2016. Full stop. Next. Our attention has been drawn by learned AGA representing the opposite parties that the order of this court dated 27/9/2023 has been complied with. First off, the dispute related to payment of compensation to the petitioner upon acquisition of land. So the special LAO NTPC Angul has opined that the land acquisition proceeding lapsed few years back. First off, in such view of the matter, step is being taken for press acquisition proposal in accordance with वो new act जो है RFCTLA RNR Act 2013. So, in our considered view, no case of deliberate violation of this court's order is made out. So, this matter stands dropped accordingly.
If you come to page 11,
Yes.
third paragraph,
Yes.
there are some direction or whatever, and contempt of this court, one direction. Third paragraph.
Yeah.
It seems an SLP was filed and to defer the disbursement of land compensation for another 4 to 5 working days.
Yeah.
In petition, page 7.
Yes, Lord.
So SLP
Filed by
was
NTPC.
withdrawn.
SLP was filed by the NTPC, who deported the entire amount
Okay.
in a contempt, saying that we are not required to deport the amount. However, we have
So what
deported
he
the amount.
contends now
That
is,
was withdrawn.
yeah, what he contends is now is that that amount is not disbursed in his
No,
favor.
cannot be below, because your lordship said directed to deposit the amount, disburse the amount as after acquisition loss. As per the old act, requisition was made for acquisition of the land. By the time 4-1 requisition was made, the new act has come into force, my lords. That is why the LO said that fresh proposal were made and the amount repeated will be paid to him as per the new act, my lord.
So the requisitions shall be made according to new act.
Yes, now it will be paid for new act.
We have,
And it was acquired earlier.
No,
You are for NTPC.
no, I was appealing for NTPC my lord, in the previous contempt application. We have paid the entire amount based on my lord the new act.
Then
Our
so
case,
that
my
will be
lord,
paid to him.
our case before the Honorable Court.
that is only, the new act will apply only for the purpose of payment.
Yes,
If the land was acquired under the old act and the payment was not made.
my lord.
If payment has been made, then what else?
So now the amount has been secured by the my lord, NTPC had reported the amount with the collector, land acquisition collector, and after my lord, so observing formalities, amount will be disbursed to them only, my lord. There is no ambiguity.
There is no question of contempt.
That computation of the amount of compensation under the new act has been made. And the amount has accordingly been deposited.
Yes.
In the.
With the land acquisition officer, my lord.
With the land acquisition officer for disbursement.
No.
To the petitioner. So, in some view of the matters, the contempt proceeding, the matter, the contempt proceeding stands dropped and in your opinion or report, no willful non-compliance of the court's order without the fact that the concern was the case. So, it goes without saying that once the amount has been released by the NTPC for payment to the petitioner, which is lying with the district land acquisition officer, the court sees no reason why the said amount shall not be paid to the petitioner immediately without any further delay. Pay it.
Yes, no.
All three cases. Who connected cases?
All are same.
Similar.
Similar.
Item number 9.
This item number 9, this is disposal of application section 28 capital A of the Land Acquisition Act. So, lastly, in all cases, lastly, have been pleased to grant 2 months time to come because we issue notice, they produce the document. So, that's why lastly, may call this matter after 8 weeks so that can comply.
8 weeks is much. 4 weeks.
No, here what is it's a they have been awarded with the amount. Now they made an application for enhancement. Now we have to issue notice to them. They will produce their documents. So some time is required. That is why also been pleased to grant 8 weeks time in all cases.
All may I for the state to report compliance of this court's order.
May I pardon to third one, your lordship. First, third item. This is the second contempt.
All right, let it.
Yes, Your Lordship. Yes.
Item number 10.
May I please, Your Lordship? Your Lordship, this contempt petition has been filed for non-compliance of the order dated 31/8 of 2023, wherein this honorable court had directed the contemner to consider my representation and pass a speaking order within 3 months, Your Lordship. Your Lordship, the order has been served since 7/9/2023. However, it has not been complied, neither it has been accepted nor rejected by the contemner. Your
Only
Lordship.
2 weeks time will also be granted. I can obtain instruction.
2 weeks time is allowed to the estate of Odisha to inform to the contemners to inform this, to report full compliance of this court's order, violation of which has been released in the present contempt application.
Bless you, Lordship.
Item 11.
Lord, all these 5 contempt petitions arise out of the common order passed in 5 writ petition, respective writ petition, my lord. The order is at page 32, annexure 5. The relevant portion is at page 37. though the certified copy of this order was produced as per the direction of this honorable court by the annexure 6, till date they are sitting over the matter without any compliance.
Here also I've gone through, Lordship may grant me only 2 weeks time. In the meantime, we'll see that it's complied with now.
2 weeks' time is allowed for the state to report compliance of the order dated 29/8/2023, passed in WPC numbers 8657, 8645, 8649, 8653, and 8659 of 2023.
My lord, by the next date, let them file compliance affidavit.
This is what we have said.
Any date is fixed, my lord?
2 weeks.
Item number 12.
Item number 12, my lord, on behalf of Mr. Dale, passable.
So, my lord, let my friend take instruction on this because my submission is these writ petitions have become infructuous. Because the issue in the involved in the writ petition which he has challenged, my lord, may kindly see annexure 1 is under challenge. The resolution. And it was before honorable single judge because some clauses of the resolution or policy decision of the government was under challenge, so it has been referred to, it has been posted before the honorable division.
So it has become infructuous. How do you say?
My lord, this annexure 1, the resolution, the matter asked me.
No, how do you say that this application has become infructuous?
No, the very subject matter under annexure 1 was the subject matter of challenge in WPC number 31679 of 2011, man. 31679 of 2011. And my lord, the order judgment in WPC number 31679 of 2011 was brought to this honorable court in writ appeal number 10 of 21. My lord. And that was also that has been disposed of on 2/20.
Thereafter, we have taken a policy decision.
Thereafter, policy
Writ
decision.
appeal.
Again, my lord. In
Then,
that
then
2011 match.
that was not, the constitutional validity was not challenged.
Yes, my lord.
Then a single bench decided. No, while sitting in single,
No.
I thought constitutional validity is challenged, so I referred to
My lord,
division bench because
I could not assist.
I lacked the
My
jurisdiction.
lord, I could not assist my lord while sitting single properly. My lord, kindly see the prayer.
The
Exactly
prayer.
challenge the
Yes,
constitutional.
prayer I have quoted.
My lord, he has said that these 3 clauses modification. Statute was not challenged. So let him take instruction on this because let him examine that issue is already settled.
Now, why don't you produce those orders?
I can, ma'am. I have. My lord will write.
Give me some minutes so that I will detach it from my file. And it has been confirmed in the Honorable Appeals Court. Thereafter, state government has taken a policy decision.
Tomorrow we will take up as requested on behalf of the petitioner. Tomorrow.
Sorry, Lordship. Item 12, Lordship. In fact, I have been informed that the issue has already been decided. But we have no instruction on that observation, Lordship. It can be disposed of all those matters. Item, Lordship.
Do you have that?
Order.
Yes, sorry, Mala, this is a loose copy.
It's a, we want on reference.
No.
That's a loose copy.
So just by referring to this order, we can dispose of?
Lordship.
In my lord, kindly also say that this order has gone to Honorable Supreme Court and
Land Council, representing the parties agree that the dispute that the issue involved in the present batch of writ application stands resolved by a division bench decision of this court dated 2/2/2021, passed in WA number 10 of 2021, which order has been affirmed by the Supreme Court also. Stop. Next, in view of the submissions noted above, these applications stand disposed of.
Lordship.
All the four cases.
Item number 13.
My lord, dealt with the similar issue on 4/3/24. This is the order, my lord. My lord, remember that there in that case 31 petitioners. Here 945 persons without any description in the cost schedule. My lords have already this. In that case, my lord, 31 petitioners. Here 945.
Same
Bless.
order comes in this.
Item 14.
May I please? In item 13, may I primarily also make all this matter along with WA number 1752 of 2023. I'm giving that order of mail.
175.
3 of 52 of 2000. I'm giving that order.
Lord, I have appeared for the hearing for the respondent. If your lordships permit, I will say something.
Permit?
If your lordships permit, I will say something. My learned senior friend is praying before your lordship to tag up WA number 1752 of 23. In fact, 1752 of 23 and this present case, principally maybe your lordship, as they are saying, it is same, but factually it is completely east and west on both the sides. Because here, what has happened, here the petitioner was asked to pray for getting admission in a +2. Here it's a regularization of Ganashikya. Where
According to you,
It has-
1752 should not be heard along with.
should not be heard. It has to be heard independently.
Now, why this should be heard, my lord?
All right, all right. It is his appeal. Let him argue.
Yes.
Your lords may see the page.
And there's a limitation also.
Just a minute.
Your lords may see page 24 of that order, my of writ appeal, my page 24, annexure 1.
Yes.
Your lords may see reference has been made to Balabhadra Maji, which I have submitted before my lords that order. That has been disposed in accordance with the ratio decided in Balabhadra Maji case.
On concession by both.
That Balabhadra Maji is challenged.
Annexure 1.
Yes, my lord. Page 24. If my learned friend says that he is not, sorry.
So this WA 1752 arises out of this order.
Yes, madam. That next page 25. That is the order for Balabhadra Maji case.
No. This 1752 arises out of this order.
Balabhadra Maji next case page, my lord. That Balabhadra Maji case.
Balabhadra Maji. All right.
Operation of this judgment. Page 20.
So this is the order under challenge.
Yes, my lord.
The state of Odisha has preferred this appeal against an order dated 18/11/2022, passed in WPC number 10640 of 2022. So it is manifest from the order under appeal that the writ petition has been disposed of in the light of an order passed in WP bracketed C number 15345 of 2022. Balbhadra Manji versus State of Odisha and others. Full stop. Writ appeal and appeal has been preferred against this court's against single judge's order dated what is that?
11/11/2022, my lord. That
Dated 11/11/2022.
25. Page 25.
11/11/2022, passed in the said WPC number 15345 of 2022, giving rise to WA number 1752 of 2023. What's wrong? List this. Delay has been condoned.
In that case, delay has been condoned.
Stop. Have you replied to the?
My lord, they have not served a copy as yet.
I'll serve in course of the day.
We are of the view that both the writ appeals should be taken up together, taken up side by side. Stop. In the meanwhile, however, let a copy of the limitation petition and
writ appeal
memo of appeal be served upon and counsel for the respondent in course of the day. Well, list this matter on 2 weeks under the same heading, so as to enable learned counsel for the respondent to consider the application and memo of appeal.
One prayer with your lordship's permission may I make? My lord, not on the week of 27th and 28th because.
Whenever as you wish.
My lord, first week of April.
Whenever.
First week of April.
All right.
Item 15.
May I please, Lordship? Your Lordship, the delay was only for 2 days. And where notice we have already issued.
So this has come for orders.
Lordship is. But
We
that
are
Lordship
controlling
come
the
for
delay.
orders, Lordship.
2 days delay.
2 days delay, Lordship.
Delay of 2 days in filing. The appeal stands condoned. Yes, also. Yes. So let it come for admission then.
Can I place, Lordship?
All right.
Small matter, Lordship.
Place.
Lordship, here, Lordship, is Sarpanch, elected Sarpanch is before Lordship. And her grievance was, Lordship, till the date of assumption, Lordship, till today.
Where is the order?
Lordship, order under annexure, Lordship, 2, that running page 215, Lordship, starts from 215.
Yes.
And judgment starts, Lordship, from 219, page 219.
Yes.
Lordship, here I had very limited prayer. Lordship, kindly come to page 220. The prayer has been quoted, Lordship, as para 3 of the writ application. Page 220, Lordship. Your Lordship, the opposite party is more especially opposite party number 6 28 shall not be directed to allow the Gram Panchayat to function independently, strictly in consonance with mandates of the Constitution.
So see your impatience. That from the order it appears that you insisted that the writ petition should be heard.
That's why, Lordship, I have given an expansion also, but
And
my anxiety
when
was.
the matter has come for condonation of delay,
No.
you.
They are.
Today, when the matter has come for condonation of delay, you want this court to hear your appeal on merits.
And sorry, Lordship, fix it.
Let it come
Maybe
for
that, Lordship, but my only limited prayer, Lordship, I am elected Sarpanch Gram Panchayat. Till the date of assumption of office, this is more than 2.5 years, Lordship. I am not able to perform and to utilize a single part from the Gram Panchayat fund due to non-cooperation of these officers. And Lordship, that's why, Lordship, that for the reasons, Lordship, I have anxiety, Lordship.
You can tell the members of your Gram Sabha.
Lordship, they have Lordship, they have continuous, Lordship, resolutions are there. They are approaching before all the authorities. And the authorities, because of due to political vendetta, Lordship, I am not able to run the Gram Panchayat, Lordship.
All right.
Item number 16.
Lordship, can it next week, Lordship?
It will be listed.
Yes, I am appearing on behalf of private respondent, my lord. There is really, I have filed my objection today, my lord. Can taken up.
Today you have filed objection for what?
For condonation of delay petition.
What is the delay? 273 days.
My lord.
What is the explanation? What is the explanation?
Lord.
Same.
May I pray? Because if, my lord, since my friend is also, young friend is also wants time, I was not suggesting subject to my lord's acceptance. My lord, may hear the case on merit. My lords are not convinced. I will take 2 minutes, 2 to 3 minutes. If my lords are not convinced, I will dismiss my case as well. So my lord may hear it next week. I will, my lords know, I will only try to satisfy within 2 minutes. If I don't have a case, I will sit down.
As requested on behalf of the appellant, list this matter on 1 week.
In the meantime, I will file the objection.
Everyone.
Item 17.
Yes. Item number 17, if a lordship sees, this is barred by limitation because your lordship's order was passed on 7/1/2021. Now this your contempt application has been filed in 2024, my lord.
Therefore, you will not comply.
No, I don't say that. My duty is to bring to your lordship's notice that, because I'm always, I can, your lordship grant time, I can obtain instruction whether it has been complied or not.
Yes, your contempt petition is time barred, Mr. Counsel.
My lord, may I submit, your lords?
Where is the order?
Yes, your lords. Order running page 12, your lords. Running page 12, Annex 1. The estimated amount of compensation. It's
Yes.
Instruction.
Yeah, running the and interest should not be from the state exchequer.
No,
Also.
right now.
4 weeks time is allowed for the state to seek instructions and file reply if so advised.
Item number 18.
May I please, Your Lordship?
Yes.
Your Lordship, on the last occasion, Your Lordship had exhaustively heard the case, Your Lordship. My only submission is that on the last occasion, my learned senior had referred to a judgment wherein my learned senior had submitted that the judgment that I am relying upon was distinguished or deferred.
You have to dictate the orders.
All right, let it come tomorrow. But
Your Lordship, one last submission, may I be permitted to make, Your Lordship? Only one submission.
what?
Your Lordship, the submission is that on perusal of the order, it can be seen that it has been mentioned that without intending to create any precedent, Your Lordship. And the the judgment that I have relied upon, many similarly placed employees have been granted the benefit by relying on the same judgment. What I am submitting is, Your Lordship, that judgment still holds good, Your Lordship. It has not been distinguished, or most importantly, it has not been set
Well,
aside.
So let it come tomorrow. I have yet to organize myself.
Obliged,
Writing
Your
the order.
Lordship.
Item 19.
Please, Your Lordship. There's a very limited issue involved regarding the jurisdiction of the labor code while exercising the power under section 33 2B of the Industrial Disputes Act. If your lordships may have a just look at the section 33 2B. May placement.
Yes, please.
Lord, 33 to be by its very nature is more of a summary procedure where the limited extent of jurisdiction is to see as per the proviso which is there in section 33 2B for the court to examine if your lordships permit, I'll just read out that proviso. Provided if your lordships have that provided that no such workman shall be discharged or dismissed unless he has been paid wages for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the employer. So this is more of a post facto approval, which is sought from the authority before whom, if any other industrial dispute is pending, and where this person may be affected by the outcome of that other industrial disputes.
So how do you say that this is post facto?
Not because the action taken, once the action taken, the action shall be simultaneous with payment of wages, 1 month's wages, and the application being made to the authority who will decide the issue after the incident has taken place. Unlike 33(1) or 33, the other proviso.
No, there are two
33(3).
requirements.
Yes, ma'am.
Payment of wages.
Wages and simultaneously filing for approval.
Application.
Yes.
So these two requirements
These
are.
two requirements have been met. So, but this court, this honorable, like relying on several judgments of the Honorable Apex Court, had expanded that 33(2)(b) proceedings jurisdiction, which is more of a judgment-made law, where it says that along with these two, what the court has to prima facie see on the available records. It cannot take fresh evidence or anything unless it comes to a contrary decision. So the things which has to be seen is whether proper domestic inquiry in accordance with the relevant rules of standing order and principles of natural justice. If your lordships, I think my associate had given these judgments earlier. If your lordships can just have a look at it. I'm a High Court. Steel Authority of India versus Presiding Officer level.
So the first requirement is that it should not be for any misconduct connected with the dispute.
Dispute pending.
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 So this was not.
This was not.
Yes.
Admittedly, this was not. If your lordships may have a look at that judgment where the court has given that along with these two aspects, which is in the proviso, what other things can be looked into? If your lordships would come to para 8 of that judgment, that is 2007 2 OLR 245. Steel Authority of India versus Presiding Officer Industrial Tribunal by our High Court.
Yes.
If your lordships would come to internal page 3 of that judgment, para 8.
Yes.
Whether proper domestic inquiry has, in accordance with the relevant rules or standing orders and principles of natural justice, has been held. Whether prima facie case has been made out basing upon the legal evidence adduced before the domestic inquiry committee. Whether the employer had come to a bona fide conclusion that the employee was guilty of the offences alleged to have been committed. Whether the employer has paid or offered to pay wages for 1 month to the employee. Whether the employer has simultaneously or within such reasonable short time is to form part of the same transaction applied to the authority before which the main industrial dispute case is pending for approval of the action taken by it, and whether there was justification for imposing the punishment, and if it so finds, it will grant approval. Now, the present case that is involved, if your lordships would see at the impugned order that has been passed, I'll take your lordships to page 16 of the brief, if your lord.
Yes.
At the bottom of it, it starts from para 5 of page 16.
Yes.
While dealing with the application under section 33(2)(b) of the ID Act, the court has to consider two things. That is, whether the workman was dismissed from service on the basis of domestic inquiry conducted observing all formalities without violation of principle of natural justice, and whether the punishment of dismissal of the workman was commensurate to the acts of misconduct level against him. So these were the two issues which he framed. Then I take your lordships to the last 10 lines of that page. It starts with, since there is no challenge. Because this was admittedly an ex parte inquiry, because he participated midway, then he left, he didn't cross-examine the witnesses and everything. So court found that yes, on record, he has been given ample opportunity. So that is the finding. But then since there is no challenge of the evidence of the management regarding fairness of domestic inquiry, I'm inclined to hold that the domestic inquiry was conducted observing the principles of natural justice and due opportunity was given to the workman to defend the charge level against him. The report of the inquiry officer is based upon the evidence collected during inquiry and there is nothing to find fault in the report. Considering the materials available on record and the discussions made above, I have no hesitation to hold that domestic inquiry conducted by the management was fair and proper. Then, my lord, on the next page, in para 6, I take to the last 6 lines of that, it starts with, he has not. The reason why he says that the punishment is not commensurate. I'll come to his authority also. He has not directly caused any loss. Here was a case where he participated in a strike, which, my lord, because of which the production of the company was stopped for almost more than 24 hours. And he was part of the persons who had indulged in that misconduct. So, but the court says he has not directly caused any loss to the company and therefore the punishment of dismissal. I'll just, my lord, I'm sorry, I'll just take few lines before that. The workman also participated. My lord, few lines above that.
Yes, as it says that there has not been any violation of principles of natural.
No, my lord. In para 6 only, if your lordship would come to 5th line, the workman also participated in a call for stoppage of work.
Yes.
By other workmen from 10 p.m. of 5/7/2009 to 2 a.m. of 6/7/2009, which resulted in the loss of production of the company. The opposite party workman did not initiate any strike, nor did he call for stoppage of work, but only responded to the call for refusal of work on a particular cause. He has not directly caused any loss to the company, and therefore the punishment of dismissal from service of the opposite party workman, in my considered opinion, was not commensurate to the acts alleged against him. The management should impose some lesser punishment on the proof of charge level against him, which he is not authorized to do. My lord, to that extent, I'll just give 2 judgments.
And what is the consequence of this order?
My lord, then he continues in employment. That is the natural consequence.
Was there any stay?
My lords?
Was there any stay of this order?
Stay is there, lord. That is why this stay was sought for, my lords. Otherwise, what happens? He comes back as if he has not been discontinued at all. And then the management has the, again, as per the order, liberty to give him a lesser punishment. So that was what he, my lord, said. I'll just, my lord, give 2 judgments of the Honorable Apex Court.
You are for the workman.
Mine.
Yes.
But I'll just read the placidum, then I'll go to the my lord, relevant paragraphs.
Yes.
33 2B and
Don't
provided
read the placetum, but just refer to the paragraphs.
Yes, I'll just. My lord, the first one is the 2019-18 Supreme Court cases.
Yes. The dispute was referred to mediation center.
No, my lord, not in this case. In the cited case, my lord, it was.
In 2019, volume 18, it was referred.
No, there earlier. That was referred, but the issue was settled, the legal issue.
Yes.
The lordship should come to para 30.
30.
Yes, my lord, that is that would be page number 64. where it starts. Internal page 15, my lord. In serial on the top, it is written 15 in the corner, page 15, but so far as the paging of the journal is concerned, it is page 64.
Yes. What has been held?
It has been held that the labor code doesn't have the power to vary the punishment imposed because for the reason that.
Where is that? Where is
Yes.
that?
If your lordship should see para 37. Which is, my lord, page 17 of the book and page 67 as pointed in the para 37.
Yes.
Lordship's got that para 37 where the conclusion has been reached. And in the other judgment that I had given, my lord, that is, my lord, 2006 5
That
S6.
is not adjudicatory power, that is what.
Adjudicatory. He doesn't have that adjudicatory power so far as the proportionality of punishment is concerned. Under section 33 2B. Because
2B.
yes.
33 2.
The reason is, my lord, I'll just explain. Because 10.1, under 10.1, a reference can be made. So even if this 33 2B application is approved, then also the workman has a right to raise an industrial dispute against the termination, where the adjudication will be made so far as the, my lord, sufficiency of the evidence, my lord, proportionality of the punishment.
So your submission is that while exercising power under section 11A,
is not available under 33 2B, it can be only under reference.
It could have been done, but not under section
33 2. That can be under a reference made under section 10.1 12.5 of the Act.
Yes, on law you are correct. But he's a workman.
My lord,
Find out.
no, my lord, I have placed my card subject to your lordship. Your lordship can remand it back. I have no objection. I had told my friend also
You please
to give him an opportunity. I don't stand in that way.
So you just discuss with.
No, that I will tell my clients. My lord, that much I can influence them. That's not an issue, my lord. Subject to lordship, but your lordship may not note my concession. That's all.
Get it. No concession. Get it resolved. We will.
That will try, my lord. That absolutely. I don't stand in the way. But so far as the law is concerned, it is my duty to.
You are right. It is very easy for us to quash the order. But it is very difficult also.
Well, otherwise, when the conscience comes into play, I understand, my lord.
And just see his misconduct also. What did he do? Did he have any other option? Do you have this option?
No, subsequently, after this incident.
Mr. Senior Counsel, we are asking you, do you have any other option?
No, my lord. I would say, my lord, the post conduct.
Not you, not
no,
your
my client.
Even as member of the bar. Times it happens.
My lord,
so,
my lord, the only after this incident, what happened was one of the officers, which became an issue in all over the Orissa, so far as the industrial sector was concerned. Their factory head was killed, was hacked to death by the very same mob, where he may not be, and
Yes, we will take up the matter after 1 week.
as your lordships wishes. Your lordships may keep it
so
the first week of April because
this
next
matter
week,
on
subject to your lordships.
first week of April will be taken up as the first case. We are not making any observation, but in the meanwhile,
we will try, my lord.
You also. Otherwise, we will have to record our judgment, and that may go against you.
Only
We are bound by law. Sympathy cannot govern us.
but so far is the allegation and punishment.
All right, it is up to you.
My lord, interim orders are there in all the three matters. So that
Interim order shall continue in the meanwhile.
deeply open.
Item number 20. Sorry, item number 21. Sorry. Item 21.
May I please, Your Lordship? In fact, yesterday the matter was taken out. I'm sorry, my lord, I could present the fact properly for Your Lordship's kind appreciation. In fact, this is a dispute. I must first of all clarify intercept between the present appellant, who is a private party, and respondent number 5. My respondent number 5 had purchased a piece of land from the present appellant by virtue of a sale deed of the year 1983. Now, the respondents makes an application before the Orissa Development Authority alleging that the road has been blocked by raising pillars and temporary structures. That is how, my lord, the cause of action for the present writ appeal has emanated. Now, under Section 91 of the Orissa Development Authority Act, the authorities are empowered to, my lord, take action so far as unauthorized constructions are concerned. Now, initially, demolition order was passed that was challenged in appeal. Again, there was a remand, and after remand, again the order has been passed. That order was challenged in appeal, and now, after appeal having been dismissed, a writ petition was filed. Honorable single judge has been pleased to dismiss the writ petition, and that is how, against that order, this writ appeal has been filed. Now, this is one line of action that has been taken by the parties. Now, the other parties, my lord, a suit was instituted by the present appellant before Your Lordship against the present respondent number 5, the private opposite party, praying therein for declaration of that sale deed that was executed in the year 1983 to be void and for other relief. Not only against the present respondent number 5, also against the other respondents, because 6 sale deeds were executed at the relevant point of time. Now, that suit has ended in dismissal. First appeal has been preferred for the learned district judge. During pendency of the first appeal arising out of that civil suit, an application for injunction was sought for. That was rejected. A civil miscellaneous petition has been filed before the Honorable Court, wherein order of status quo has been passed. I was pointing out yesterday to Your Lordship, that is at flag 1, Your Lordship, that is there before Your Lordship on board.
So there is no dispute about one fact, that the structures and the pillars are over the same land, which were the subject matter in the suit, and now in second appeal, first appeal.
No, first appeal is pending for the London district judge. In the first appeal, the interim application was rejected. Against that,
Only the subject matter, we are not on that.
I have nothing to dispute about that. The only thing is that, my lord, the subject was with regard to cancellation of the sale deed. Now, the respondent number 5 claims that in the sale deeds, there was a right of passage, the passage is being blocked. Now, during the course of hearing of this appeal, on the basis of an undertaking given by the present appellant, those 2 pillars have been removed. And that has been also confirmed by the CDA. My learned friend Mr. Mahapatra is appearing for the CDA authority. My learned senior Mr. Mukherjee is appearing for the respondent number 5, the private opposite party against whom I am at loggerheads.
Now those two pillars have been removed. All through the proceeding, Your Lordship, what they indicated is two pillars and other structures. They never indicated about that half constructed Hanuman temple and a tin shed. Now, when a query was made by this noble court with regard to the other structures, they have clarified here before this noble court by filing an affidavit that the other structures means, my lord, this tin shed and the shop room. That is what they have clarified. That affidavit before Your Lordship is that flag D, Your Lordship. That is the affidavit of the CDA authority. One thing I beg to humbly point out to Your Lordship, that in the IA that has been filed, that is IA number 241 of 2022, Your Lordship, that is at flag B. I have annexed a notice that was sought by the CDA authority at page 6.
Yes.
Therein, Your Lordship will kindly find that they have mentioned other temporary structures. One thing I beg to humbly submit for Your Lordship's kind consideration is that they never specified so far as the other temporary structures are concerned. Now, they are qualifying this before this noble court saying that the other temporary structure means this. And that is by way of an affidavit, which is at flag D, Your Lordship. So there they clarify that the other temporary structures in paragraph 5 means this shop room and tin shed. Now, my lord, though the order of the original authority and appellate authority has not been appended to this appeal memo, since the writ petition is before Your Lordship on board, may I draw my lord's kind attention to the original order that was passed on 15/7/2008, that is at Annex 15 to the writ petition, page 77.
In fact, Mr. Senior Counsel, we are not convinced. We are of the view that the order of the learned single judge is correct, requires no interference.
Only one line.
Because of the pendency of the appeal, that matter of civil dispute. We cannot stop you from making your submissions. You can make.
Only one line I will submit.
Yes, we will
I bow down to Your Lordship's view. I have nothing to say because I have definitely suffered now in 3 forums concurrently. I am conscious of that. Unless I show some kind of perversity in the conclusions, certainly I will not have a chance to succeed before Your Lordship. The only line of submission I humbly beg to make before Your Lordship is that this entire initiation was at the behest of respondent number 5, Your Lordship. There is no denying of that fact. With regard to a right of passage. Now, intercept between the appellant and respondent number 5, an order of status quo is in vogue as on today. So, my lord, if Your Lordship will not interfere, the effect would be that the order of status quo that has been passed also may rendered as infructuous. That will be one of the issue. Only I beg to draw Your Lordship's kind attention. I have nothing more to submit except that. And that order, my lord, has been filed for Your Lordship at flag 1, Your Lordship, that is there. This much, I have nothing more to submit for Your Lordship. I am grateful, man.
Yes.
Well, to that, the last submission that was made by my learned friends, that status quo order that he is referring to, that is with regard to the land that I have purchased. The demolition order, which is now subject matter of appeal, that is the passage. It has got nothing to do with the land. These are two distinct parcels of land. If Your Lordship will see the sale deed, that makes it clear. The sale deed at page 25 of the writ petition. That is the page 4 of the sale deed. Absolute owner, scheduled properties along with compound wall. After taking possession, third line, after taking possession of the scheduled land from the father, Ramakrishna South, the vendor shall allow common road, marked common road in the map, measuring 60 decimals, 26 lengths in breadth and 230 lengths length, running from south to north on the land for the exclusive use of the vendor and the vendees, along with the 4 purchasers, namely so-and-so, which includes me. No other persons except the vendors having successors or vendors and their successors and other 4 purchasers stated above cannot claim any right over this common road or disturb the exclusive possession of the vendees of this road running from south to north shown in the map annexed here to approximately valued at ₹50. So now what has been done is the offending constructions, if your lordships will take page 73 of that brief. Page 73.
Of the
yes, of the writ petition, Writ petition, there the unauthorized constructions has been delineated. Shop rooms 3 numbers, gate pillar 2 numbers. And this is on the road. This fact, my lords, will be borne out if your lordship takes my affidavit, which I have filed in the appeal, which is at flag F.
Page number?
Flag F, my lords. Flag F. There's an affidavit filed with the respondent number 5.
In the writ appeal.
Yes, my lords. Writ appeal. At page 3 are the photographs. Your lordship will find the pillars, the offending pillars that have been put up on the road. And then there is a Hanuman, there is a temple which is visible on the middle of the road. And behind that, there are 3 shop rooms.
Flag A.
Flag F.
F.
F. Page 3, your lordship sees the photograph which I have given. Now, your lordship clearly sees the passage, and on either side of the passage, there are pillars which have been put up, ostensibly to affix a gate so as to prevent the entry. Then your lordship sees the structures which have come up in front of the tree.
No, but these aspects can be seen in the.
They have, and that is exactly what has been ordered by the authority, that remove this. This is a road.
Yes.
Ma'am, I'm appearing for Cuttack Development Authority. Because the case has a checkered career. Once some allegations were made that some construction has been made over the road, then we initiated a
No, what is your comment on the order passed by the London Single Judge?
So that is well in consonance with law. Well in consonance with law, our demolition order has been upheld. But only I am to point out only 2 aspects for minors clarification. I think it will clarify the whole total position. First of all, minors, I'm coming to the the read petition is there before minors. That is what I'm pointing out. Actually, what my learned friend says that we have not pointed out what are the other structures. To that minors, one clarification is necessary. First, my humble submission. To that minors, kind of a glance to the order passed by the appellate authority in earlier occasion, remanding the matter, clearly stating therein what are those structures. That is at page. Page 73 to the read petition. I think got it. Page 73. That is an appeal case under section 91(2) of the Odisha Development Authority Act.
Present appellant.
The appellant Dolgovind Sahu was appellant before the commissioner under section. It is appeal under section 91(2) 2 of the Odisha Development Authority Act challenging the demolition order passed under section 91(1) of the Odisha Development Authority Act. Dear matters that clearly the learned appellate authority clearly specified what are those unauthorized constructions. Matters, I think matters got it.
Stops 3.
Stop number 3, unauthorized
Gate
construction.
pillar.
Deviation is said unauthorized construction. Stop number 3, gate pillar number 2. I understand if a pillar is so far that part of that boundary, but it is over the road itself.
Second.
Get it, man?
Yes.
Now, thereafter, last portion. In view of the above
First
context.
one is deviation in setback.
Yes. Stop
Unauthorized
number 3,
constructions.
the deviation was known to the parties. It's not that they do not know what is that deviations or what is that unauthorized constructions under demolition. Means under the proceeding under section 91 of the OD Act, Odisha Development Authority Act. Thereafter, it was remanded. After remand, now minus the impugned order is at page 79.
Yes.
Well, so straight to minutes, I'm coming to page 83. Page 83, last word, 1, 2, 3, 4, 5, 6, 7, 8 lines. 8 from bottom 8 line. Therefore, the opposite party cannot claim his exclusive right over the road. Moreover, the construction of 2 pillars and raising other temporary structure over the common passage cannot be considered as boundary wall, as pointed out by the advocate for the opposite party, and as such and such thereafter manner the demolition order was passed. So the demolition order, what my learned friend appearing for the appellant stated, that the demolition order only in respect of 2 pillars and not in respect of the other structure, I think is not correct, is not of the record, my lords. What is my humble contention? Then, my lords, what happened? They preferred appeal again. And in the appeal, they only challenge about the 2 pillars, not in respect of the other structures. Now, my lords, pursuant to the direction of the Honorable High Court in this appeal, I filed a affidavit, my lords. That is in D. Well, sir, that D, flag D, my lords. I enclosed a sketch map. What they have done is sketch map, my lords. That is at page 11. This is the latest position, my lords, on survey up by the field staffs.
Yes.
Got it, page 11, that is sketch I have given, not in scale, of course. 2 columns. I've stated
Page
in
11 of what?
2 minutes.
Page 11 of?
Page 11 of my affidavit, my lords. Affidavit filed by CDA, my lords. By one Gyanendra Prasad Samal.
No.
On 13/2/2022, I think flag D. Flag D, no?
Just a minute, please. Close the whole page. 21. Yes, you are referring to?
Minors, the page 11, the sketch minors, the existing, present existing position.
Your affidavit.
Affidavit is like?
Flag D.
Flag D.
Yes.
Minors, page 11, the sketch, the present existing position. Minors, the pink color, 2 columns.
पुराना टीना घर अर्ध निर्मित हनुमान मंदिर.
Pink color, 2 columns, they demolished. They say
concrete pillar.
Yes, concrete pillar, they demolished. Other 2 minors, I've shown it in minors, the yellow color. These are the 2 structures, means these structures Earlier, you were used as a shop room, now being converted to Hanuman temple and half built Hanuman temple. Other was in
Which is referring to
instructions.
affidavit D.
That is over the road matters. Now, my lords, if the appellate authority, while dealing with all these things, also consider that this road is being used by the municipality, developed by the municipality, used by the public, and it is an easement now. You are undertaking construction over the road itself, and that these are all part of this demolition order confirmed by in the appeal. Now, my lords, the Lord's Honorable Single Bench upheld it. At the later stage, now a point is being raised that the order is the demolition order is in respect of the 2 columns only and doesn't cover those structures.
Yes. Anything else?
Now, this is what my humble submission. They are to remove it. If they will not remove it, obviously, at their cost and risk, of course, the BDCDA is to demolish it, exercising power under Section 91 of the Odisha Development Authority Act. This is my humble submission.
Just one line, my lords, submit that this order of demolition, which has been passed, which is being assailed and should be sustained. That is one thing. Second is, your lordship, may I also request your lordship to set a deadline, because I am the person who is affected. I am unable to come out of access my land or come out of it. So a time limit be fixed for the appellant to remove it. If he does not do so, let the CDA do so within a time specified by your lordship.
We'll see.
That's all.
I'll clarify only one thing vis-a-vis the submission made by the Land Council for the CDA. Land Council for the CDA said that I have not challenged all the demolition direction for the appellate forum is not correct, for the reason that your lordship will find from the appellate order at page 11 itself, page 12, relevant page is page 12. The challenge is the instant appeal has been filed under Section 91(2) of the Odisha Development Authority Act in pursuance of order dated 2011-2008 passed by the Honorable High Court of Orissa in WPC number so-and-so, challenging the order dated 15/7/2008 passed by the Law Officer Cuttack Development Authority in UC case number so-and-so, wherein appellant was directed to remove the structures undertaken over the common passage in question within 15 days from the date of receipt of the order. So therefore, the entire thing has been challenged. That is one part I beg to clarify. The other part is the affidavit that was being shown by the council for the CDA to your lordship at flag D. Your lordship will only see one thing from that affidavit, page 12, that the road is there to the left side, 11 feet road is there. So road is in existence, that is why I beg to point out. And the last is with regard to that civil court order, status quo, my humble submission would be that will have a binding effect vis-a-vis the entire thing, because shall deed includes the right of passage. Now the order of status quo definitely will cover everything. So therefore, to say that it will be segregated is not a correct submission. This is what I meant. Obliged.
Only just to add one thing, my lords, here in this case, so far my learned friend says, we are demolishing unauthorized construction.
Now, since you are making your submissions, he will have a right to reply. And then once he may complete this submission, you will start.
That will not never end. I understood, my lords. I think, my lords, we have clarified the things, my lords. The only thing at point of law, here in this case, 91 is for demolition of unauthorized construction.
Everything is there on record. We will see.
Always wants to have the last word. Obliged.
For the purpose, my lords, only to clarify their legal position, not in respect of facts.
Grateful, man.
That's also. It is 4 means for check. Did. In that.
It has gone to the Honorable Supreme Court in SLP and it was listed on 27/2. And I will intimate the Lord's order thereon. Recently, just now I have obtained the instruction.
Where is he?
Pardon me.
You are paying, the matter has gone to Supreme Court.
That is what my learned senior has.
So no contempt is made out.
But thing is that if it is accepted the SLP, then I think your lordship may at least give a week time me to confirm this. What order has been passed on that day? If the SLP is not entertained.
It has been stated by an additional government advocate that the state of Odisha has preferred an appeal before the Supreme Court against this court's order dated 18/5/2023, passed in WP bracketed C number 18837 of 2022. Stop. 2, violation of which is being erased in the present contempt application. Stop. And counsel for the petitioner seeks adjournment to verify the latest position of the said matter pending before the Supreme Court. Stop. As requested, list this matter on 1 week.
Yes, a week.
Item 3.
In item number 3, the opposite party number 1 has directed the engineer in chief to comply with lordship's order forthwith. Some time may be granted so that we can do it. So I've got the instruction to comply the order. All the parties concerned, those who are to must comply.
It is for item number 3. Learned AGA upon instructions has submitted that urgent steps are being taken to ensure implementation of this court's order dated 13/7/2022, passed in WPC number 25502 of 2014. So list this matter on 1 week as the first case for the estate to report compliance.
Item number 43.
Please, your lordship.
We had heard this matter.
Yes, ma'am. Last occasion, your lordship asked the government to file an affidavit with regards to what happened with regard to what the status of the 3/3/2023 DPC.
My lord,
They were to file the affidavit today.
Have you filed?
My lord, pursuant to my lord's direction, we sought for instruction and the affidavit has come. But my lord, the contents of the affidavit, somehow there is some dispute. So also I have sought the intervention of Lord Advocate General. May I pray, my lord, this matter may kindly be taken up on Monday.
Seek their consent.
My lord,
So the whole thing is that the 2024, I have got the instruction that 2024 DPC they have already undertaken and they are going to issue the notifications. Then
No,
the entire
that you
thing will
should
become-
not do.
They should not do it at least.
because my lord's direction was interim order that keeping 5 posts, go ahead.
No, if you want, we can decide. The matter on whatever, on the basis of whatever material is there before us. You cannot ignore completely 2023. We prima facie, we are satisfied that there was no illegality. Submission.
My lord, 23 DPC, 3 persons have been promoted. Rest, it has not been worked out.
No,
3
rest-
persons who are admittedly senior to all petitioner, respondents, everyone.
So no one has any
No one has any. Rest
grievance
person,
against that.
None has been given promotion. That information is there in this affidavit, but there are certain other information which should have been brought to the notice of this honorable court has not been given here. So we have not.
All right, 1 week we can give you further time.
No, Monday will be ready.
1 week, Mr.
Let it be on Monday because from Tuesday I will not be there. Your Lordship.
Monday, all right, Monday.
Since they are praying for Monday, let it be on Monday.
All right, Monday.
Monday.
Monday is 18th.
Monday is 18th, Your Lordship.
18th. Learned AGA has submitted that the instructions which he has received from the state government as regards the departmental, as regards proceedings of
Your Lordship, compliance of Your Lordship's order dated 7/3 already.
in compliance of this court's order dated last order
7/3
are insufficient, and he requires further instructions to stop. As requested, list this matter on 18th
18th, Your Lordship, at 2 p.m. Your
to
Lordship.
be taken up at 2 p.m. All right. Two p.m. Right.
Yeah. Let them not go ahead with that. That will be my only prayer, Your Lordship. Let them go ahead with it. They should restrain their hands.
Let them do.
Then the entire case will be there. Only matter of only 3-4 days, Your Lordship.
To support the order of the Honorable Single Judge, I may be given an opportunity to submit on Monday.
Yes. And in the meanwhile, you can give your, all of you,
Yes.
can give your written notes.
We have filed, but the additional subject, if they can give me
We have
also by Friday, we can also file that affidavit.
We have all, if you
So you have to satisfy that there is no illegality in 2023.
Yes.
And he has to tell that these are the
Your Lordship.
We have also already filed our notes. They have been
The issue is very simple.
Yes.
So not at all.
We have in fact got
Fight
one.
may be big,
No.
but the issue is not that big.
So vis-a-vis only employees, only the same cadre.
Yes.
So that's
It happens.
In fact,
Service
if I can
matters.
simplify,
there should not be discrimination.
basically, this issue deals with two regimes. Either you have post Nagraj regime where you conduct the exercise. If you don't have that regime, then you have to fall back on Ajit Singh
The
Juneja.
problem with you, Mr. Mishra, is that you cannot take help of Nagraj.
Yes.
That is the whole problem.
If we are not allowed to take the help of Nagraj, then the question would be that those judgments of the Honorable Supreme Court will be just mere paper decrees.
No, because you did not avail. How can we unsettle what was settled long back?
Now, so far as that delay, for us, if the delay is taken into account, a 4-5 year delay of not challenging their express orders of promotion, there is one 5-judge bench judgment of the Supreme Court where I have brought. If your Lordship want, I can show it right away, which says that if this delay is something which is a matter of discretion, in appropriate cases, the court can exercise. May I just show that judgment?
No, we show. File it with the.
What I would basically submit is that the Honorable Single Judge has
Give
taken.
me citation in the meanwhile.
I will give copies.
Please.
Monday, man, 2 p.m.
Monday.
Juneja 2.
Item 22.
We are all great.
Great.
May I please, Your Lordship? Page 14, my lord. Order of the Honorable Single Judge.
Page
14, my lord, Annexure 1. 1 form. Only question for consideration here, my lord, whether during pendency of a criminal case, one is entitled to get regular promotion or not.
we have recently decided.
Yes, Your Lordship has already decided a issue in W number 16 of 2024. So that order has not been uploaded.
Tomorrow.
Yes,
In the meanwhile, the order, I believe that.
Well,
The order shall be uploaded. Or day after tomorrow.
Item 20,
If not around Friday. Right.
item 23,
My lord, in this case, my lord, this honorable by the order dated. By the order dated, my lord, 29/1/24, my lord directed me to produce the rules. Actually, my lord, we had sent letter. Today, also if my lord will give me 2 days, I will produce the rules. I have not brought. Because it is in the counter, my learned senior showed that because of specific environment that in accordance to the rules, but which rule it was not.
The counter
Typically-
filed by the state is in favor of the petitioner, not the appellant.
I will produce that.
What is ORV Act?
Or we have to reservation act.
Reservation.
1970.
This is a single post that way.
What is your problem? Why are they not giving you the rules?
Actually, my lord, I won't say it's their fault.
All right.
I should have.
When do you want?
My lord, may give me 2 days time.
All right, as requested on behalf of the state. So as to comply with this court's order dated 29/1/2024. List this matter on
Any day next week. Any day
Monday.
next week.
Monday.
Or the interim order is there.
Interim order shall continue in the meanwhile.
Great.
item number 24,
In item 24, I have taken consent of my learned senior. Lordship, may call this matter next week because I have to verify one original application that has been relied in this order. If that is covered by this, then I have nothing in this case. Next week, I have taken consent.
With the consent of learned counsel for the respondent.
My
Your
lord, sole
respondent.
respondent.
Learned page.
Return not income. I will take out tomorrow. Along with return note, I have given all the document, all the judgment of this one. I will appeal to my lord. Yesterday I mentioned also item 38 that 38 I mentioned that taken along with that written note. Not come today.
What do you want?
Tomorrow, man, along with written note. Not me. Only tomorrow.
I am a
I only not wait to tomorrow, man.
Tomorrow.
Along with written note submission.
It is requested on behalf of the appellant. You are the appellant.
My lord, I am appellant, man. All the cases.
Since my lord, I will be getting the written note today. My lord may grant me some time to go through that.
Written notes and written notes. Let's see.
I only enclose the judgment of my lords and this one could appeal to my lord. Written note.
We'll see tomorrow.
My lord.
Not me.
Item number 26.
I pray for my lord, kindly pass over, my lord. Pass over. One pass over. On behalf of Mr. Malik.
As requested. Tomorrow.
Item 27.
May I pray for 2 weeks time to file the additional affidavit?
As requested. Additional affidavit for?
Additional affidavit as we have filed prior form of the affidavit.
All right. Additional
Ma'am.
additional affidavit. All right.
Item 28.
May please,
Okay.
Lordship. May please, Lordship. I am for the petitioner first case, my lords. I prepared a date chart, my lords. Here, my lord, this matter relates to additional fee imposed under Rule 81 of the Central Motor Vehicle Rules. My lords, here, my lord, the first one notification has been issued, that is 29/12/2016. Notification issued by Ministry of Road Transport and Highway, Union of India, increasing fee and levied additional fee under Rule 32 and under Rule 81 of Central Motor Vehicle Rules 1989 by way of amendment. That is, my lords, annexure 2 to my writ petition, my lords. Next, my lords, the 3/4/2017, my lords.
Now, what is your relief?
And my final grievance is, my lords, this 2016 notification has been challenged before the Madras High Court, and that has been struck down. So far, the imposition of additional fee, that has been struck down by Madras High Court. Then, my lords, they filed the SLP before the Supreme Court, Union of India. That SLP, no stay has been granted. Then, my lords, some batch of writ petitions and filed before this honorable court. And this honorable court in 2 judgments, my lords, struck down that additional fee also. Again, in 2021, by Annexure 5, they levied again the additional fee when the matter is subject matter for the Supreme Court, and also no stay has been granted. And that is the 2016 notification. The same thing they have done it. There is no difference.
Which provision has been struck down?
Your Lordship, this is the
That
judgment,
is-
my lord, this honorable court.
Which provision has been struck down?
That is Annexure 2, your lordship, my lords. Annexure 2, my writ petition.
Serial number 11,
That is
column
page-
number 3, note table, rule 81.
My lords,
That has been struck down.
Rule of what?
my lords, your lordship may see the Annexure 2, my lord. That is the notification. Page 16, my lords. Page 16. First case, my lords. First writ application.
Annexure 2, yes.
My lords, Annexure 2, your lords may go to page, starts from 16. Your lords may go to the page.
Annexure 2, page
20.
16.
I am sorry to interrupt, my lord. Sorry to interrupt. In this case, I'm seeking some time because 2 ground. One, admittedly, what my lord has submitted as regard the notification is concerned issued by the Ministry of Road Transport as regard to the imposition of additional fee, as well as the fees. Subsequent notification was made, which was not before challenged, but one notification has already caused by this High Court. This High Court. But on the same self issue, one judgment is in Paris, Chennai Madras High Court, against which SLP preferred. It is pending.
But
Leave
no
granted.
stay has been granted.
So what I'm praying, my lord, let me take an instruction that what is the stage of this SLP?
That is pending, my lord.
Because this. What happening on website? I checked it out. It is coming that the council, who this party who has owned the case in Chennai, in SLP, he is not appearing in 4 occasions. He is not cooperating with the court. That's why it couldn't be adjudicated. This is situation, my lord. As regard to our case is concerned, it is required to be challenged for why the government has not taken, or my predecessors or other give opinion not why it was not challenged. No. But issue is similar. So I think the government may think that one issue may be settled, then
Issue
or
may
it
not-
will implicate all over
issue may
India.
not- Issue may not be same. As earlier, as I recollect, Mr. Prabhakar Behra, he was submitting that in 2016, the exercise of power was under section 110.
No, my lords, 211 my lords. In there, my lords, that is under section 211. Yeah, I have annexed that notification, my lords. Annex 2.
That is what I'm saying, and
210, there is no my lords.
sir, what I said, don't you hear?
Sorry, my lord.
Page 16.
Yes, my lord.
Now, therefore, in exercise of power conferred by section 110 of the Motor Vehicles Act, the central government do make this, hereby makes the following rules. That is what. So that was struck down. So now you have come up in 2021 saying that in exercise of power conferred by section 64 of the Motor Vehicles Act. That is the subtle
It is a
distinction.
subsequent, it is, yes.
Subtle distinction which Mr. Behra was pointing out, as I recollect from the earlier hearing.
My lord, yes, ma'am.
I was sitting.
Honorable Justice Shorten.
Yes.
My lord.
So there
is a distinction between both the notifications.
My lord, apart from this, scrapping policy, as you know, my lords knows that Government of India has to give a scrapping policy. The commercial vehicle will fixed to 15 years. The private vehicles, it was fixed to 20 years. They are giving the priority to the commercial vehicle first, and they are imposing 50 rupees only. Those are extending their period of 15 years. They will pay 50 rupees. Against which several petitions have been filed, and they are before my lord. In the meanwhile, the High Court has passed an order. Chennai, the Madras High Court has passed another order, which is pending with the SLP. What I am praying, my lord, the against.
We must make it clear.
My lord.
That if there is statutory provision, which is struck down by any constitutional court, that stands struck down for the whole country.
Exactly.
Because it is not
Only the impact, yes.
It is not that a statute declared illegal by
particular, yes,
will be a whichever notification has been issued
my lord.
Now, that has not been subject matter of challenge before any other high court or
exactly, it is not.
That has been challenged with the Karnataka High Court. That has been challenged also Kerala High Court.
Kerala High Court.
Both the High Courts, my lord, granted stay.
Yes, I have already submitted. The copies are there.
Copies are already there, man.
No, there is earlier notification. My lord,
This
recent notification. This was not the
present notification that is
this notification, 2021 notification.
Supply the copy.
Yes, copy with you. Copy. You have to collect your central copies there.
I know how to control the court proceeding.
Right.
And this is not the way. Please don't compel me. One by one, please make your submissions.
Well, may I pray? Let's me give some time, then I will examine, then I will.
Let me understand first.
Okay.
Yes, you are correct. Kerala High Court order is there.
There.
There is also Karnataka also there.
Karnataka also there. That time also I'm
23rd Amendment Rules 2021.
2020.
That was subject matter before the Kerala High Court. Which you have.
Kerala and Karnataka.
Karnataka also. Last time also your lordship have given.
I think that is not before us.
No, where is the stay of the notification? Which notification has been stayed?
That is 2021 notification has been stayed, my lord.
Where is that order?
Yes, yes, that is there.
High Court doesn't stay the effect. Bound to, staying something which has statutory force has a very serious consequence. So normally the courts don't do that.
My lord.
So therefore, there is no stay of that notification.
No, that the order is there that they will not collect. They are not
They will
collecting.
not collect. That is different. And that is to the authorities of the state of
It is
Kerala.
only said that without insisting
My
for
lord, my
additional
lord.
fee.
Yes.
That doesn't tantamount to say
Yes, yes,
that notification, the effect of notification has been
No,
stayed.
that is there.
Notification-
That is there, that not
notification,
to collect, not to
You
insist.
can't
to
understand
collect.
like
My
that.
lord.
You can't
Yes,
interpret the court's order.
If some order has been issued by, say, a central government, which has application throughout the country, and if one high court stays the that order, then that will have application throughout the country, because the effect of that order itself has been
No,
stayed.
that is not
But
to
here
insist.
the
my lord.
notification has not been stayed. You are making an incorrect summation.
Sorry, my lord.
One order is there, Honorable High
Let
Court
us-
Karnataka.
Let us see.
My lord, the operation of notification dated 4/10/2021 issued by the first respondent annexure 4 is stayed till the next date of hearing. my lord.
All right. let us-
Your lordship. Sorry for another copy, not there. ma'am.
Bring this on affidavit. You also seek instructions.
Yes, please.
Yes.
This is the
Which is it?
WBC number is there, ma'am.
What is the challenge in the presented application?
That is the 4/10/2021.
The first petition that is annexure 5, my lords.
All other cases annexed 2.
Case number କେତେ ଶୁଣିବ? ସବୁ ଗୋଟେ ପେଜରେ ଚଳନ୍ତି ଆଉ ଦିଟା ପେଜ ରଖିଛନ୍ତି।
ଦିଟା ଦେଇଥିଲେ। After the
Petitioners in the present batch of writ applications have put to challenge a notification dated 4/10/2021 issued by the Ministry of Road Transport and Highways, Government of India, bracketed annexure 5 in WPC number 23387 of 2022. Stop. It has been argued on behalf of the petitioner that Karnataka High Court, that the High Court of Karnataka has stayed the operation of the said notification by an order passed on 5/5/2022. Stop. Next. Learned Deputy Solicitor General of India seeks adjournment to seek instruction. Stop. As requested, list these matters on 2 weeks. After 2 weeks.
Can I make, my lord, after 3 weeks, can you?
3 weeks.
Item number 29.
Oblige. May I please? Page 19, annexure 2.
Annexure 2.
My lord. Page 19, 19.
Yes, what is wrong in the order?
Yes, what is the wrong in? Your lordship may see read petition. There was no such allegation we have said any, he has said anywhere you have insisted him to file a case. And second aspect, if he is not entitled to third RACP, he cannot claim that benefit and we cannot grant them. What he is claiming, my lord, he is claiming the third RACP, a third RACP, my lord, that abbreviation I revived assured career progression at the rate of 6,600 grade pay.
No.
Yes, madam.
The court records that there is an order that benefit will be granted only to those candidates who have obtained order from the court.
That is wrong, my lord. Your lordship may see his read petition. There is no such allegation against us. I have annexed that read petition, my lord. And there is a difference. He is not entitled to the same benefit as has been granted to others who have approached the court.
How do you say that?
Yes, that I am saying, my lord. Your lordship may see revived career assured progression. It is granted by the as per the finance department notification dated 6/2/2013. As per the same notification, one is entitled to 3 financial upgradation at the interval of 10, 20, and 30 years.
Yes.
So, my lord, he was granted 3 upgradations. The lordship can find it from page 21. He entered into service on 26/6/1984.
26.
6/1984, my lord. So he completed
27th June.
27th June. Your lordship may
1984, he entered into
service. So he completed 30 years as on 26/6/2014.
Yes.
Your lordship may turn to page 21.
So 94, 2004 and 2014.
2014.
10, 20 and 30.
30. So he will be granted third RACP with effect from 26/6/2014. There is no dispute about it. And he has admitted that he was appointed so and so. There is no dispute. Enter dispute lays here, my lord. Your lordship may see at that point of time when he completed 30 years, that there were 3 grade pays. Grade pay of 4,200 and 4,800 and 5,400. His grade pay was fixed at 5,400 at the third RACP. The 5,400, you'll also see page 22.
Yes.
The grade pay of 4,800.
Page 22 is an Annexure 4.
My lord. My lord, the post was upgraded earlier the grade pay was 4,800. It was upgraded to 5,400. Your Lordship, that was taken into effect from the date of issue of the notification. The notification date is 8/6/2015. He claims that he is to be fitted at the second RSCP at the 5,400 and third RSCP at the 6,600. By that time, he has completed 30 years. He is not entitled to be covered under this notification. And he has completed 30 years as on 26/6/2014. The Honorable Court had directed to grant him RSCP from 8/6/2015. And this has been disputed at the very first day, my lord.
No. It's according to you, he or she, he was entitled to third RSCP with effect from 26/6/2014.
Because he completed 30 years.
Was he completed
30 years.
And what is this? This annexure 4.
Annexure 4, my lord, that next post was which was 4,800 was the grade pay. That post was upgraded and the grade pay was changed 5,000 to 5,400. Trust me, the grade pay, which was earlier it was 4,800, it was upgraded to 5,400.
So now just let us understand that if there is an employee who had joined in 1986.
Yes, ma'am.
All right.
Yes, ma'am.
So he would be entitled for third RSCP with effect from some date in 2016. So this fellow will be getting more pay because of this 2015?
Yes, ma'am. Because that post was upgraded. And this has come into effect. This has come into effect from the date of issue.
Therefore, if your submission is to be accepted, then someone who had joined in 1986, junior to this fellow who had joined in 1984, will be getting more benefits against third RSCP compared to this person who had joined in 1984.
My lord. In fact, he is not getting more benefit because of that. If he joined in 86, that he is getting 2 less increments. Because one who has joined in 84, definitely he must be getting 2 increments more. But this has been taken effect from that date issue of the notification. And this has been disposed of at the admission stage, my lord, without giving us an opportunity of being heard.
Yes, madam. Why should we decide the writ petition? It should have been decided at the.
My lord, there is other writ petition in the similar matter which has been decided. So, single judge.
But the counter affidavit ought to have been taken. First, when was the case filed? What is the date of filing of the case? Writ petition. July 21. 9th July 21 and 10th July 21 the writ petition is posted on. Okay. remanding it. The state of Odisha has.
Well, before disposal, I will bring one fact to my lord's notice. There is a delay also. Your lordship has issued notice on that delay. So it should.
How is
I should-
523 days.
In
The
fact,
de-
not 523, that period will be condoned, that late COVID period. So there is some delay, my lord.
There is a delay of 523 days
No, that
in
will not.
filing writ appeal by the
That
government.
during that COVID period, the matter has been disposed of.
There are also
So-
11 months delay.
So I should brought to my lord's notice that regarding delay part, because your lordship has issued notice on that.
There,
But on the merits of the
My
case,
lord,
this,
COVID period
that I have,
for 21.
yes, I have to bring my,
No, during
this fact to
COVID,
my lord's notice.
during COVID, the matter was disposed of. Okay.
That
But
I am bringing
that
this fact to my
limitation-
lord's notice, because unless this fact is brought to my lord's notice, admitted there is a delay. For that reason, I bring it my lord's notice. But on the merits
Have
of
you
the
filed your objection?
yes, my lord, I have filed one person. Since the matter listed for condonation of delay, my senior sent me.
No, have you filed your objection?
Yes, my lord, I have filed one objection.
Where is that?
Objection filed on 23/2/2024.
No, you are dismissing it then.
but on merit, I have brought my lord's notice. This is the fact.
This appeal filed on behalf of the state of Odisha is barred by limitation. So there is delay of 521 days in preferring the appeal. No, stop. And counsel appearing on behalf of the appellant has argued that because of the COVID situation, COVID-19 situation, the appeal could not be filed within a stipulated time. Stop. Further, the decision making at the level of the department also took time for preferring the appeal. Stop. From the permits made in the application seeking condonation or delay, it appears that there is no explanation as to why the appeal could not be filed soon after 28/2/2022, keeping No, prior to. March 2020.
January 20, when have you filed?
On 20th January 2023.
23.
23. 6
Much after that.
8 months, sir.
11 months delay.
Soon after 28 to 2022. Oh, stop. It is noteworthy that the Supreme Court had directed exclusion of the period from 15/3/2020 till 28 to 2022 for the purpose of computation of period of limitation. Also, it took more than 1 year for the state. When did you file?
On 20th January 2023.
About 1 year for the estate to file this appeal. Also, we do not find any satisfactory explanation for the delay. So this application, this appeal, sorry, the limitation, this application is accordingly dismissed. The appeal stands dismissed as a result of dismissal of limitation application.
Item 30.
My lord,
You should delay lordship.
the order dated 21/9/21 is under annexure 1 is under challenge, but before I take my lords to the order, I must bring to my lords notice that there is a delay of 245 days. One. Number two, my lord. He is a Gram Rozgar Sevak. The writ petitioner before my lord was a Gram Rozgar Sevak. He challenged his order of disengagement only on the ground of authority, jurisdiction. The Honorable Court, this Honorable Court relied upon a judgment of this Honorable Court, coordinate order, order of the coordinate bench of this Honorable Court, which also said that the collector had no authority, but in a writ appeal, this Honorable Court has held that collector had jurisdiction. While saying so, I also must bring to my lord's notice that on the date of passing of the impugned judgment, the judgment in the writ appeal had not come. So this is the factual scenario. And my lord, limitation is 245 days. The merit is, my lord, the finding of the Honorable Single Judge that collector had no jurisdiction has been found to be incorrect in the writ appeal court.
No, we are not going.
My lord, both item 30 and 31 are same. There it is 245 days. In item 31, it is 246 days.
Only number 349 of 2023. This application has been filed for condonation of delay in filing the present intra-court appeal. There is delay of 245 days in referring this appeal. So stop. Following is the explanation given in paragraph 5 for delay in preferring appeal Put as paragraph 5 of I number. The explanation so put forth is not at all satisfactory. So the appellants have not been able to make out a case that because of sufficient cause, the appeal could not be sufficient cause. The appellants were prevented from filing the appeal within the stipulated time. So this application is accordingly dismissed. So next, consequently, WA number so and so also stands dismissed.
31.
31 my lord, 246 days.
246 days.
Item number 32.
In both the matters may make a small prayer, lordship, because I'm a contractually employed. Because of this writ appeal, I'm not able to engage lordship. Let them allow to engage lordship. Now they may allow to re-engage lordship because
they may do it.
Lordship, that a small objection may make lordship. It is
32.
If you want us to enter into the merit of the case, we are ready.
no, lordship. Then I'll approach them. Lordship.
32 my lord, on behalf of Mr. Das my lord, kindly pass over my lord. 32 my lord, on behalf of Mr. Das my lord, kindly pass over my lord.
It be passed over for the day so that it can be tomorrow they are in the list because.
Item 33.
Your lordship.
I'm not appearing for the appellant, my lord.
Lordship, yesterday I have received the copy of the rejoinder. Lordship, I'm needing some time to look after it. Let it come next week.
You are petitioner.
Lordship, respondent number 5.
Respondent number 5. When was the rejoinder filed?
Yesterday. They have supplied me the copy yesterday.
It is stated by land counsel for the respondent. But in writ appeal, why the rejoinder affidavit is that required?
I am for the opposite part number 4. I have filed counter affidavit.
Why? Why should we allow?
Not necessary.
The writ appeal is to be decided on the basis of the materials which were there before the learned single judge. Why counter rejoinder? Nothing is required. So let us start. No affidavit. We will not look into any affidavit. Other than the pleadings which are there.
Yes. The fact of the case is like, my lord. Appellant joined in the school as a Hindi teachers in the year 1996, my lord.
1996 joined.
9/10/1996.
Hindi teacher.
As a Hindi teacher.
Then?
During 2007, February 2007, she applied for leave for about 35 days. February and 2007 and March 2007. In 2 spell, applied for leave for about 35 days.
Yes.
Thereafter, the then managing committee did not allow the petitioner to sign the attendance registers, nor allowed to take class, my lord. As because name of the applicant was listed in the staffs of the school up to the year 2008 and 9. And thereafter, in the year 2009-10, when they found that her name has not been placed, so she filed a representation before the respondent number 3, the then CI of schools. Now it is designated District Education Officer Puri, my lord. Respondent number 3. In the year 2009. Though respondent number 3 issued notice to the managing committee to produce all the records with regard to complaint made by the petition appellants, but the managing committee did not produce. And the CI assured me to take actions, but they have not taken action in spite of repeated representations and reminder. Then I filed an applications before the respondent number 2, Director Higher Education on 1/11/2013, my lord. So the respondent number 2 issued notice to the respondent number 3 as well as the managing committee and the school administration, my lord, headmaster. Yeah. They appeared, but they did not produce any records, my lords. The order of the respondent number 2 is at Annexure 7, my lord. I may be permitted to place the order, my lords. That is in the details they mentioned. Annexure 7, running page, my lord, 50 to 53. May I place, my lord?
Yes.
Srimati Nirupama Misra, terminated Hindi teacher, Lavan Satyagrahi Swamiji Purnananda Vidyapita Puhudi in the district of Puri, filed an appeal before this forum on 1/11/13 through her advocate for a direction to the Secretary Managing Committee to allow her to work as a...
Thereafter. This is in your favor.
My lord, this is in my favors.
Then
the respondent number 5 as well as the Managing Committee, they filed two writ appeals against the order.
Managing committee.
My lord, both respondent number 5 and the Managing Committee, though they filed two writ appeals, and the writ appeal was heard jointly and order was passed under Annexure 1, my lord. The contention before the Honorable Single Judge was that by both the respondent of 5 and Managing Committee that the petitioner was informed in spite of for honorary absence, notice has been served. Thereafter, termination order was also served, but she did not challenge it in time. But the respondent number 5, so the Managing Committee never produced any record. When I represented before the respondent number 3, that is CIF school, in the year 2009. So also when I filed appeal for the respondent number 2 and the order was passed on 22nd January 2015 by the respondent number 2, no record was produced by the record. That I have been noticed and notice has been served. So also the termination order was issued and it has been served upon me. They did not enclose any document in the writ petition also. The Managing Committee has never produced before the CIF school when notice was issued in the year 2009.
No,
So,
but the single judge has relied on an order dated 26/10/2021. Passed in WA number 379 of 2019. Come to paragraph 15.
So this is with regard to compliance of explosions, millets. But here my humble submission, millets, as I was not allowed, I have requested the CIF school with immediate authority. And in spite of notice, the Managing Committee never produced any documents. Never even I was informed, millets.
The court is of the view that no rules of natural justice was required to be complied with.
But in the case, millets, they have not even served any notice to me, or even termination order has not yet been served upon me, millets. And that part the court
the finding.
But the finding of the court is that since I filed the decision of the respondent number 2 dated 21 January 2015 is belated, and I have filed applications in late, so such an application cannot be entertained. I have never been given any notice. I have never given any copy of termination orders, which they have never also enclosed in the writ petition also, though they relied. They intimated to the respondent number 2, accordingly respondent 2 submitted report to the respondent number, respondent number 3 reported to the respondent number 2, and so also both appearing before the respondent number 2.
Mr. Counsel, please come to paragraph 15.
My lord. That each case is to consider matter on the basis of one merit, my lord. In my case, my lord, they have not communicated any intimations to me, my lords.
No, it says that in that event, there was no obligation on the college in question to have, in fact, complied with any rules of natural justice.
So in that case, the college has produce the document, my lords, the next sentence, my lords. So in my case, my lord, they have not given any intimations to me.
No, no, in that case that was given, but the court says that there was no requirement. Where is that decision?
My lord, I beg permission, my lord, to sort adjournment so that I'll go through that decisions and in details and submit on the next day.
That is the reason. Whether leave was sanctioned.
No, they have not sanctioned. They say that I have been given notice and my services are terminated in the year 2007 itself, my lord. But there is no intimation to him. Even when I'm represented to the CIF school in the year 2009,
So
and notice was issued.
when did you realize that you have been your service?
I have not been informed, my lord, because even when I approached the CIF school, they have not informed anything.
So when did you realize?
After submission before the director, that I have been served notice and I have been terminated.
So when
In
did
the
you
year
go?
2014, my lord.
2014.
14, my lord.
Necessary.
But no copy of order has been communicated to me.
All right.
Let's see, may please.
All right, we are not satisfied. The applicant was working as a Hindi teacher in a private school, namely Lavan.
My lord, Lavan Satyagrahi
Swamiji Purnananda Vidyapith Kohdi in the district of Puri. First off, it is an admitted fact that the appellant absented herself from February 2007. So it is the appellant's case that he had applied for leave in February 2007, initially for 35 days, and subsequently in the month of March, again for 35 days.
No, my lord. In the February, it's 17 days. In the March, 18 days. So total that
17 days and 18 days. So stop. It is the appellant's case that after availing the leave, when she attempted to submit her joining, her joining was not accepted by the school authorities. Stop. Indisputably, the school is run by a private managing committee.
Right.
Stop. There is also no dispute about the fact that the appellant did not work in the school thereafter. That is from March 2007. So stop. See, thereafter approached where did you approach?
9/10/2009.
Approached director?
No, my lord. To the inspector of school, respond number 3. He is the immediate authority.
The inspector of schools, bracketed respond number 3, raising her grievance that she was being harassed and was not being allowed to join. Full stop. Where is the director's letter?
Director, Annexer 7, my lord, running page 52. That is the order of the.
During the course of pendency of her representation before the inspector of schools,
my lord,
the appellant is said to have learned.
No, my lord, I have not been informed. When I filed appeal before the respondent number 2 director in the year 2013, and the notice was issued to the CI of school, give a report.
No, what happened before the inspector?
He has not communicated anything to me, my lord. She issued a letter to the managing committee on 27/10/2009.
So thereafter you approach the director.
No, thereafter I waited and represented before the CI, respondent number 3. I made multiple representation to communicate what is the decisions. No decision was communicated to me. There ultimately in 13 I approached the.
Actually, correct. It is also the case of the appellant that the inspector of schools, that as the inspector of schools did not take any desired action on her application, she approached the Director Secondary Education, Odisha, Bhubaneswar. When?
1/11/2013.
On 1/11/2013. So apparently thus, 6 years after he was not allowed to join in the school, she approached the Director of Secondary Education, Odisha. So stop. The district education officer issued notice to the management of the school. So stop. It was a strict stand taken before the Director Secondary Education, Odisha, passed an order dated 22/1/2015, holding that the managing committee of the school did not follow the due procedure and did not give the petitioner a reasonable opportunity before terminating her service. And accordingly, directed the managing committee to take the petitioner back to the post of Hindi teacher in the school. So stop. Next. It is relevant to mention at this juncture that it has been argued by learned counsel on behalf of the appellant that only during the pendency of the matter before the district before the Director Secondary Education, Odisha, she learned that her services were terminated. Stop. Next, be that as it may, comma, from the said order of the Director Secondary Education, dated 22/1/2015, appears that the district education officer had reported that the applicant had performed her duties till 1/3/2007, but she remained absent from duty from 12/2/2007 to 28/2/2007, and from 2/3/2007 to 19/3/2007 without any intimation. So stop. The school authorities had issued notice to her seeking her explanation, but the petitioner applicant did not respond to the notices, and accordingly notices whereafter the managing committee terminated the services of the petitioner. Stop. Next. The said order dated 22/1/2015 passed by the Director Secondary Education came to be challenged before this court by who is Kedarnath Soin?
Lordship, respondent number 5. After the appellant was terminated from service due to a long absence, a respondent number 5 was appointed in her place as Hindi teacher.
A management did not file any.
Management also filed another writ, and private respondent number 5 also had filed a writ.
There were 2 writ petitions.
Lordship.
What happened to the writ petition filed by the management?
Common order.
Common order was
Under Annex 1, common order.
But that's not mentioned. Is that
Lordship, I
mentioned?
beg to state a point.
All right. Management. Before this court by the management of the school. Management of the school by filing writ petition giving rise to WPC number
Lordship, 3231 of 2015.
management
No, management lordship, that is WPC 5612 of 2015.
5612 of 2015.
Lordship.
Stop. The said order was also challenged by on the college in question in that case to have complied with any rules of natural justice. Stop. Next, assailing the impugned order of the learned single judge, learned counsel appearing on behalf of the appellant has submitted that the petitioner, that the appellant was not even made known about the termination of her service by the management of private management of the school, comma, let alone complying with the principles of natural justice. First off, he submits that taking into account all the relevant materials available on record, the director had rightly come to a conclusion that that appellant's termination of service was contrary to the principles of natural justice and had rightly directed the private school, management of the private school to take the the appellant back. Stop. Learned counsel representing, next part, learned counsel representing the management of the school. And who are you?
Respondent number 5.
Who are you?
Number 4.
Kedarnath.
Headmaster cum
That's why I'm for
secretary.
Kedarnath Swai. My learned senior is for managing committee of the school.
And learned counsel for respondent number 5 have argued that it is evident from the admitted facts that the appellant had virtually abundant unemployment, and in such circumstance the college was left with no other option but to engage another teacher for a smooth functioning of the school. Stop. They have also argued that the circumstance in which the school had to take a decision to terminate the services of the petitioner did not require adherence to the principles of natural justice. First off, in any view of the matter, as it is evident from the report of the district education officer, which has been taken note of in the order of the Director, Secondary Education, that explanation was sought for from the appellant. Stop. Next. Considering the admitted facts that the appellant remained absent from duty without any leave having been granted to her, and absent from the duty since February 2007 without any leave having been granted to her, and she approached the Director, Secondary Education nearly 7 years.
And 13. 7 years.
Nearly 7 years after the order of termination order was passed. When?
That's your termination.
7 years thereafter.
That's your termination of order was passed on 22/11/2008.
No, my lord, it is not never been brought to my knowledge, my lord. Even when the respondent number 3 directed the managing committee in 2009, they did not produce.
Are not persuaded.
Before the director also, they did not produce any records.
To interfere with the impugned order of the learned single judge in the present intra-court appeal. Stop.
I beg pardon, my lord. I beg pardon to submit a fact, my lord. My lord, when the respondent number 3 issued notice to the managing committee, they produced no records. When the director also issued notice, the managing committee or even the respondent number 3, they produced no documents with regard to issuance of notice or the order of termination to me, my lord. They filed it individually. They also not enclose a single document with regard to service of notice or issuance of notice, so also the order of terminations. On that background of the matter, the director has directed to take me back into the service, my lords, because the order of notice or termination was never communicated to me. When the respondent number 3 submitted a report to the respondent number 2 in the year 2014, then only it came to my notice. But no documents, my lord. Till date, I am not in possession of document. So also they have not filed a single document with regard to issuance of notice or service of the termination order or issuance of termination order.
Lordship, may be permitted, Lordship. Just a single point, Lordship. Lordship, paragraph 10 of the order about the Honorable Single Judge Lordship, the director, secondary education, he lacked jurisdiction to entertain any appeals of termination. He was not the appropriate authority who should have interfered with this. Lordship, may kindly come to para 10 of the order of the Honorable Single Judge. The regional joint director was only competent to hear appeals, Lordship.
No, my lord. Director or secondary education is the competent authority as per.
But this has been reflected in the order.
That is not.
Lordship, paragraph 10. It is therefore crystal clear that after 15th of December 2000,
Yes, it is also wrong.
My lord, director is the higher authority, my lords. That is the distribution of the powers. So director can assume powers, my lords.
That is also circular.
So it has been pointed out by Land Council appearing on behalf of respondent number 5 that the learned single judge has rightly noted in the order under appeal that the director higher education, secondary education, did not have the authority to entertain any appeal against termination of service of an employee of a private educational institution. Top. In response to the said submission, when counsel appearing on behalf of the appellant has submitted that since the director is higher authority than the regional joint director who has been vested with the power to hear appeals, the director also have the same power.
And one more point, lords, because I have not ignorant about them and my terminations when I submitted application for the director. So the question of file appeal before the joint director do not arise, my lord. I simply made application because of the respondent number 3 has not taken any action on my repeated representations.
He has also argued that the petitioner the appellant did not have any knowledge about termination of service, and she had just made a representation before the director, which was entertained as an appeal.
My lord.
Stop. Next, the submission made on behalf of the appellant that the director has the power of an appellate authority because he is an official superior to the regional joint director school education is wholly misconceived. First of all, single judge has rightly noted in the impugned order that the director secondary education did not have the jurisdiction to exercise appellate powers. After 15
December
12 2000. So stop. Next. Accordingly, we are of the view that
I beg pardon, my lord. I given one chance, my lords. I will given from the manuals as my friend is submitting, director has the power to hear an appeal, my lord, when application is received. One. Second, read appeal, that is relied in 15th also. I want to go to it. So I pray some time.
We do not find any legal infirmity in the impugned order passed in the order under appeal passed by the learned single judge requiring this court's interference in the present intra-court appeal. This appeal is accordingly dismissed.
Item 34. Much obliged, Lordship.
Pardon. In this case, I have been engaged for the appellant. Unfortunately, the assisting counsel, because of his difficulty, suddenly left me. I only pray for tomorrow from the list itself. I am not praying for any deferment.
All right.
Tomorrow from the list itself.
All right.
God bless.
Item 35.
May I please? My lord, the order impugned before this honorable court is Annexure 1. My lords have already dealt with a similar order. The Annexure 3. My lord, may kindly turn to page 34, please. My lords,
Yes.
page 34. Now, this writ appeal came to be, my lords heard this writ appeal, 1280, and my lords have on 4/3, sorry, ma'am, on 4/3/24, my lords have dismissed. But here, as I take my lords to the my lords order dated 4/3/24, I will try to persuade this honorable court as to how the present case stands in a slightly different footing. May I take my lord first to that order. My lords will remember that I was trying to persuade my lords that laboratory assistant having higher qualification, lower
No,
qualification.
but you cannot challenge this order.
My lord,
You are challenging this order dated 29/2022. Page 13.
my lord, my lord.
You cannot challenge it.
This
Read paragraph 4.
My lord, but that 1280 was challenged. That order was also challenged before my lords. That's what I was showing, my lord. Annexure page 34, I was showing, my lord. This very WPC OSC 3436 of 2013 was on the
decided here.
Decided here. My lords have decided. Initially granted misstay, and thereafter my lords have decided on 4/3 only. This honorable court. Now,
therefore, this appeal.
My lord, only two things I will try to persuade my lords. Two. My lords have held here two things. One, that
Dismissed. Dismissed. Sure, this is your concession. Your concession has been recorded in paragraph 4.
Well, true. So, my lords have that order I gave, my lords order.
Yes, but we cannot see that for two reasons. One, that this order dated 25/2022 has been affirmed by us. One. And two, according to your own submission, his case was covered by this.
My lord, that was the submission. But two things, sorry, I will not take much time. Two things only that my lords here, while affirming that order, my lords have held two things. There is no record or there is no material on record to show that the post was created with a lesser scale. This was the main feature on which my lords dismissed my writ appeal. Here, my lord, we have given the document. At the time of appointment,
given the document, you can seek review, but you cannot challenge the order. The order has been passed because of your concession, because of your submission. You could have taken that plea.
Concession may not be binding. You can challenge as
yes, you can seek review. You can seek review. You can say that it was wrongly mentioned. Whatever.
But now this order is affirmed.
Therefore, the state of Odisha has preferred this appeal, challenging an order dated 29/2022, passed in WPC bracketed OAC number 3435 of 2013. The said order by the said order, a learned single judge of this court disposed of the writ petition in terms of a judgment dated 25/2022 passed in WPC bracketed OAC number 3436 of 2013. So stop. It is noteworthy that learned additional government advocate had contended before the learned single judge that the writ petition could be disposed of in terms of the said judgment dated 3436 of 2013. So stop. In such view of the matter, it is not permissible for the state of Odisha to question the correctness of the said order by filing an appeal. So stop. Next, it is also noteworthy that a writ appeal referred against the order dated 25/2022 passed in WPC OAC number 3436 of 2013 has been dismissed by this court by an order dated 4/3/2013 passed in WA number 1280 of 2022.
My lord, 4/3 of 2024, my lord.
In
It has wrongly been mentioned.
wrongly mentioned, I think. WPC OSC
My lord.
3436 of 2013. It should have been 13.
3 has been typed in place of 2013. Of this appeal, we do not find any merit in this appeal, which is accordingly dismissed.
Item 36.
6, my lord, I am for the respondent number 225. My lord, 1 week after Mr. Raut is not available. 1 week after launch. I am for the respondent 225.
As your lordship, please. As requested on behalf of the respondent, list this matter on 1 week.
Item 37.
My lord, item 37, my lords had heard it to some extent on 6/3. Thereafter, now my lords will remember a batch of writ petitions my lords heard. They were class 3 employees, RSCP wrongly fixed. They had retired. So in view of Rafiq Mashi, we couldn't recover. So my lords gave me that observation that yes, if now the pension is to be refixed, then we may do so in accordance with law. Here in this case, my lord, this case was also tagged to that batch, but that was deleted from that batch. Here, the Honorable Single Judge has held that he is entitled to that scheme. He is entitled. There it was entitlement in those cases were not fixed. Only our recovery was quashed in view of the decision of Rafiq Machine. Here, so that's why my lord allowed me to argue on merit. Now, my lord, dates. 2, 3 undisputed dates I will give, my lord.
Yes.
My lord, here the writ petitioner was appointed on 10/7/1979.
Ten seven
1979.
Pointed.
My lord. Then, my lord, here 3 posts are important, my lord. Fireman is the initial post. Then leading fireman, the next promotional post. Then the assistant station officer, they are in one cadre. The next promotional post is station officer. Now, my lord, now the fireman enjoys a grade pay of 1900. The second leading fireman or major havildar, which the petitioner, read petitioner was, enjoys the scale of grade pay of 2200. The assistant station officer enjoys a grade pay of 2400. And the station officer, my lord, enjoys a grade pay of 4200, which my lord Honorable Single Judge has allowed. Now, my lord, I took my lords through that very important paragraph 6 to 13, which the very notification which gives entitlement, eligibility and entitlement of RSCP in favor of the employees, ma'am. I have taken my lords to para 10 of that resolution, ma'am, of that notification. My lords have seen it, and my submission to this honorable court was my lord, on RSCP, 10 years, 20 years, 30 years. What you get, if you are not getting promotion, 10 years, you get the grade pay of the next post. 20 years, grade pay of the next higher post. 30 years, the grade pay of the next higher post. But that is a cap, my lord. One cadre. One cadre. That must be within the cadre. You cannot get the grade pay of the next cadre post. Here, the station officer belongs to another cadre. These are admitted position, my lord, undisputed. It cannot be, it's not disputed here, at least. Now, my lord, so here what happens? The person was, 1987, this person was promoted. Petition.
Promoted to?
Promoted to Major Havildar. Driver. Driver Havildar. Driver Havildar. So his grade pay become 2200.
Leading fireman.
Leading fireman or driver havildar, they are same post. So the petitioner was driver, then he becomes driver, leading fireman or driver havildar.
So driving, when did he become driving havildar? 87.
1987.
1987.
87.
So he will not be entitled for the first.
Yes, madam. Now he will be entitled to, on 20 years, he will be entitled to 2400. Next grade pay.
Next?
2400. The next grade pay, madam, that is important, 30 years.
No. After 20 years, he will be entitled for what?
2400, 2400 grade pay.
No, you said 3400.
No. First is 1900.
First is 1900.
Then is 2200.
2200.
Then 2400.
24, you said 34.
No, that is 2400. I'm sorry.
24, are you sure?
My lord. That is a grade pay of the assistant station officer.
All right. So he would have been entitled to 2400.
2400 in second RSCP.
In second RSCP.
Yes, ma'am.
Yes.
Now on third RSCP,
yes,
he won't get 4200 because station officer belongs to another cadre.
So what will he get?
He will get 2800.
2800.
Yes.
All right.
Now this is my case.
All right. How?
That is my. I will take my lord once again.
2800. Where is that?
My lord, that is the pay schedule, my lord. That document is there in the in our.
How do you say that this is not in the cadre, station officer?
This is not disputed, my lord. Station officer is another cadre.
Cadre is always decided by the cadre rules.
That is our specific stand. That has not been. That has not been disbelieved by the honorable.
And you may take a stand. We have to write a judgment.
I'll bring that cadre.
You can bring that cadre. You must be having cadre rules. You may be having some decision of the Cadre is,
Yes, I understand. I get my.
cadre is strength of a service.
Yes, ma'am.
So if your submission is to be accepted, then this station officer does not fall in the service of this.
Yes. I'll give that.
You are relying on para 10 and para 10 fourth line. The employees of the cadre having promotional hierarchy will get the grade pay of the promotional post.
Yes.
So you mean to say that within the same cadre,
Yes.
the higher grade pay will be he will be entitled, not the next higher cadre.
Yes. If my lords accept my first point, my lord, that was my submission. That
We don't know whether we will accept or not.
yes, I'll show that cadre. I'll show that cadre.
In my rejoinder to the writ petition, my lord, I have given the document. The AS assistant sections have been promoted to the post of section.
No, promotion. See. The only question is whether there is any cadre of 4 services, 4 posts like fireman, this and this, and the station officer also.
Yes, ma'am.
All right.
Apart from that, I have the issue has been settled by this honorable court in judgment in division bench.
What has been settled?
Again, the RACP has been passed in a screening committee under the rule, my lord. That is paragraph 3 of the scheme. Once screening committee has passed the order, in my case, screening committee allowed me in 2013. I retired on 30th April 2019. After retirement, my lord, they are now trying to reverse it. Court says you cannot reverse it. Yes, sir.
All right, we will see those. Yes. First of all, there are 2 aspects.
Yes.
You may not be entitled to,
yes,
and you got it. So we may have to deal with that circumstance.
Yes.
Now here the court says that you were entitled to that grade pay of 4,200. The stand which the state is taking that 4,200 grade pay is not available to you because you did not belong to that cadre.
Yes.
Because that post does not belong to that cadre. So we don't know where from this cadre has come and how, on what basis the submission are being made. As requested on behalf of the state, let's this matter on Monday.
My lords.
Item number 38.
Please, my lord, sir. At the last hearing, my lord, I submitted before your lordship that the petitioner before your lordship is an educational institution and it is exempted from the purview of Employees Provident Fund and Miscellaneous Provisions Act. And my lord, that by operation of section 16 of the Act, my lord, this educational institution is exempted. And my lord, operation will not do. There must be some decision. The Employee Provident Act. That submission of yours appears to be expressly incorrect. Lordship may kindly see section 16. Lord, submission is, Lord, relying on a decision of the Supreme Court, which has been followed till 2023, 99 Supreme Court, Lord, willful judgment. Lord, I submitted if the order is total without jurisdiction, the writ court can interfere because the alternative remedy is not effective alternative remedy. But I was relying on that judgment in the. We also know those judgments. That your lordship find on that date, my lord. Therefore, Lord, why do you want us to act as an appellate authority?
No, my lord, it is total without jurisdiction. Had it been within the jurisdiction, my lord,
and they committed some mistake, my lord, your lordship would not have reserved.
No, would this examination come within the purview of writ appeal?
My lord,
Mr. Counsel, what my lord is saying, that this plea could have been entertained by the learned single judge.
Lord.
But once the learned single judge has taken a view that you have alternative remedy and you should go there, we are not sitting in as an appellate authority over some inferior court.
Lord,
It's an intra-court appeal.
my lord, my respectful submission with all humility I submit, my lord. Lord, that view is erroneous, my lord. That is why I am before your lordship and I am troubling your lordship with this appeal, my lord. My lord, if it is totally without jurisdiction.
Still, you are not answering our query. Still, you are not answering our query.
That's right. My lord, I understand, my lord, your lordship is exercising the appellate
We are
jurisdiction.
in letter pat. We are in
Yes, my
letters pat. So,
Your lordship, my lord, your
whether
lordship.
that comes within the domain of letters pat.
Lord, if it is without jurisdiction, my lord, if it is erroneous, my lord, and in the appeal everything
The
can be
order
gone
is
in.
without jurisdiction, then why did you file a writ petition?
My lord, it is, my lord, I filed the writ petition because the order is totally, impugned order is totally without jurisdiction. The writ court should interfere and save the petitioner, my lord, from the entire process of harassment, my lord. That is why, my lord, I approached the writ court and writ court, my lord, without...
One wrong leads to another wrong. If we entertain this.
No, my lord. My lord, a person will be saved, my lord, an
We
institution
are not
will be...
examining the jurisdiction of the learned single judge.
My lord, if something is erroneous, my lord, it can be corrected, my lord.
In writ appeal.
Lord, your lordships have jurisdiction, wide jurisdiction, my lord. Your lordship is exercising the, my lord,
writ appeal, we
powers
don't
of the
have
appellate
the
authority if it is
jurisdiction, sir.
total without jurisdiction. And especially the, my lord, honorable single judge, my lord, did not examine any aspect of the matter, my lord, and simply relegated me to the
As my
appellate
lord has
authority,
said,
my lord.
we are not sitting in appellate jurisdiction over the inferior courts. We are examining the order passed by the learned single judge.
By this court.
Right, my lord.
You are challenging an order passed by this court in this court. Do you understand the difference
Lord,
between other appeals and this appeal?
Lord, this the writ appeal is the provision, my lord, where
The writ appeal is provision is a different matter.
Lord, where everything can be examined, my lord. That is
No,
where, my lord.
everything you
My lord, your lordship may kindly see, my lord, I'll show your lordship section 16, 3 pages of my writ appeal and 1 Supreme Court judgment, and I'll leave you to your lordship. My lord, your lordship may kindly see 16(1)(b). To any other establishment belonging to or under control of the central government or state government whose employees are entitled to the benefit of the contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefits. Here, my lord, here in this case, your lordship may kindly see 3 pages. My lord, your lordship may kindly see 3 pages of the writ appeal. My lord, page 44. Lord, page 44, 45 and 56. 46, my lord. 44, my lord, it is notified for the information of the all concerned that Vice Chancellor on so and so exercising powers of the syndicate has been pleased to grant permanent affiliation to the institution. Thereafter, my lord, the next letter, my lord, the affiliation is subject to fulfillment, my lord, extension of the my lord, permanent affiliation. Thereafter, my lord, the next letter, my lord, your lordship may kindly see permanent recognition. My lord, in exercise of power conferred under section 16 of the OEA Act 1969, the committee constituted in the government notification number so and so after careful consideration has been pleased to grant permanent recognition from the academic session 2006 and 7 to degree classes under the named institution, the detail mentioned herein. My lord, this institution is a recognized and affiliated institution, my lord, under the Odisha Education Act, my lord. And my lord, this is coming within the purview of section 16(1)(b), my lord. It is under the control of the state government, my lord. At this stage, my lord, I will place before lordship, my lord, 2 rules. Odisha Aided Educational Institution Employees General Provident Fund Rules 1983
and aided educational institutions, Odisha aided educational institutions employees retirement benefit rules 1981. Lord, these two rules, they take care of the provident fund and all other need, Lord, requirements of the employees of the Lord, that college, Lord. Therefore, Lord, my respectful submission is, Lord, on the basis of Lord, this Rule 16, Lord, this Act Section 16, Lord, that this is within the control of the state government, and by virtue of Section 16, Lord, this institution is exempted from the purview of the Provident Fund Act, because Lord, provision has been made by the state government, Lord.
Where is the provision?
Provision, Lord, 16(1)(b).
No, provision made by the state government.
Lord, state government has framed two rules. Lord, so Odisha aided educational institutions employee general provident rules 1983. And Odisha aided educational institutions employees retirement benefit rules 1981. These two rules, they will take care of the retirement needs of the Lord, those.
No, contributory provident fund is there.
Yes, my Lord.
Where is
That rule, my Lord, Provident Fund rules 1983.
Where is that?
Education Act, my Lord.
Where is that? Contributory provident fund.
Odisha
It is
educated
there,
education
benefit of
institution employee general provident fund rules.
Huh?
General provident fund rules.
We are putting a question.
My Lord, I'm sorry.
Whether there is any scheme for contributory provident fund.
My Lord, may I, at this stage, my Lord, may I submit, my Lord, my state council, my Lord, they are able to answer in a better, my Lord, position, my Lord.
So they will argue your appeal?
No, my Lord. My Lord, that is there, my Lord. My submission is, my Lord, these two rules are there. They are framed by the state government.
Mr. Counsel, you are referring, you have mentioned 100 times rules, section 16B. All right.
Man.
So there is an expression. There should be benefit of contributory provident fund.
Yeah.
We are putting this simple question, whether there is any scheme. We intend to impose exemplary cost in this appeal. You have wasted court's time. Tell us. You are saying that the everything was there and it was beyond jurisdiction. And single judge ought to have considered every aspect. Because you are institution, therefore you can spend any money on litigation.
And my Lord, one more case, my Lord, I judgment had placed before your Lordship.
We will refer to that judgment before imposing cost. The appellant. In the present appeal claims that it is governed by the Odisha Education Act and rules. First off, it is admittedly a privately managed college. First off, but according to the appellant, it is under the control of the state of Odisha, where the tribal students are given opportunity for their higher studies in the college. Stop. Next. Assailing a notice
dated 16/8/2022 regarding attachment order issued by the Recovery Officer, Regional Office, Bhavishya Nidhi, Regional Office, Bhubaneswar. The petitioner filed a writ application before this court under Article 226 of the Constitution of India, which gave rise to WP bracketed C number 21309 of 2023. First off, a learned single judge of this court disposed of the writ application with an observation that as the petitioner had alternative remedy of appeal, this court, the court was not inclined to entertain the prayer made in the writ petition. The said order of the learned single judge dated 12/7/2023 is under challenge in the present intra-court appeal filed by the appellant. Stop. Learned counsel appearing on behalf of the appellant has submitted that since the impugned order of attachment passed by the officials under the Employees Provident Funds and Miscellaneous Provisions Act is wholly without jurisdiction, the learned single judge ought to have entertained the writ petition and declared the action of respondent number 3 to be illegal and unsustainable. Stop. He has heavily relied on Section 16 bracketed 1 bracketed B of the Employees Provident Funds and Miscellaneous Provisions Act 1952 and a decision of the Supreme Court rendered in case of Regional Provident Fund Commissioner versus Sanatan Dharm Girls Secondary School and others, reported in 2007, Volume 1, SCC 268. Which paragraph?
Lord, paragraph, my lord, your lordship may kindly see the last paragraph. Paragraph, my lord. 39, my lord.
With a special reference to paragraph 39 thereof. Stop. Next. Section 16 1B reads as under. Stop. It is apparent on plain reading of section 16 1B that such establishments belonging to or under the control of the central government or state government are exempted from the application of the Act, whose employees are entitled to benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefits. Stop. Despite our repeated query, learned counsel appearing on behalf of the appellant has not been able to point out that the employees of the institution are entitled to benefit of contributory provident fund. Stop. In such view of the matter, we refrain from making any observation as to whether there is any benefit available or not for the employees in the absence of any material. Stop. It is a matter which can be adjudicated, which should be adjudicated upon at appropriate level. So stop. Next, in our considered opinion, the present appeal against the order of the learned single judge, whereby the appellant was given a liberty to avail alternative remedy, is thoroughly misconceived and deserves to be dismissed with a cost which is assessed in the facts and circumstances to be 10,000. So stop. Accordingly, the appeal is dismissed with a cost of rupees 10,000 to be deposited in the account of Odisha High Court Legal Service Committee within 2 weeks.
Lord, may I submit one, madam? Lord, imposition of cost is a reflection on the ability of the council, my lord. Lordship may kindly consider that aspect.
Item 39.
Item 39, may I pray tomorrow, my lord? Tomorrow,
Yes.
day after.
Well, 1 week after, my lord, I will file
Is
a.
appearing for respondent.
My appearance, okay.
39, 1 week after, my lord, I will file a counter. Obliged.
A counter in appeal will not permit.
Well, I file an affidavit.
This is not good
No, no,
practice.
that's right. That is
Appeal, there must be counter affidavit in the writ proceeding.
order.
Why should you file counter affidavit?
Is a-
No counter affidavit
Actually,
in
something
appeals.
is, they have mentioned in it, factually.
Sorry. No affidavit, no counter affidavit in appeals.
1 week after.
As jointly requested on behalf of the parties, let's this matter on 1 week.
Item number 40.
I may please your lordship.
May I please your lordship, my lord, I am for the respondent number 4, my lord. I am the proper party, Odisha Power Transmission Corporation, my lord. In spite of repeated direction made by the lordship, they have now served a copy of the writ.
Oh, why are you so agitated? What happened?
Let me submit my facts.
In spite of repeated direction, he has not
Please
served.
control your movement of your hands. Yes, what happened?
Copy of the writ application has not served, my lord.
All right, who? You have filed appeal.
Yes, my lord.
Please give him a copy.
Sir, I will give, my lord, definitely. Sir, I will submit the fact why this is urgency. I am moving with your lordship. What happened? The government of Odisha has empowered the transmission company, Odisha Power Transmission Company, to go for a notification.
This is writ appeal 1742.
Miller.
Yes.
So, by virtue of a notification dated 10th August 2015, what they have said under 164 of the Indian Electricity Act, they are acquiring certain, they were transmitting lines from the particular area from one station to another station. So within that area, my land is about 2 acres or more is coming along with a building and a farmhouse. So then we have resisted after this. Why the compensation is being paid under the Telegraph Act. Earlier in 1885, when Telegraph Act was, the intention is mere pole of 2 square feet. Now they are erecting high tension towers, which needs at least 1500 to 1600 for base area to construct pillar, and then they erect. Then thereafter that land is completely being unused by the appellant. So
what do you want?
So we want, my lord, that we have challenged the notification. Instead of that, we should be compensated by the Land Acquisition Act.
But there is already an order passed by the learned single judge.
My lord, that learned single judge has not considered because a resolution thereafter has passed by the government.
Therefore, you give him a copy of appeal, we will consider.
My lord, I will definitely, I'm just putting the fact.
Have you seen order dated 4/8/23? Have you complied?
4, Miller?
4/8/23.
4, 8. 1 minute, Miller.
Have you complied?
that single.
Thereafter, many occasions you have sought for time. This court's order 4823.
So instantly, I don't have time at that order. So I'll submit there after some time, my lord, because this is exactly I am not having that order, my lord. So
You are in a hurry and you have not removed the defects.
So, my lord, sorry, my lord. So I'll take.
You should feel sorry.
Sorry, my lord. So defect is that I have not seen.
All right.
Because
So by what time?
so by tomorrow itself, I will remove the defect, my lord.
By way of last indulgence, the Land Council for the petitioner is permitted to remove the defects, failing which this appeal shall stand dismissed without further reference to the bench. Yes.
Item 41.
May I please your lordship? This is a matter wherein the first appellate authority has been imposed with a penalty of 15,000 as per section 20 of RTI Act 2005, whereas the statute as provided under section 20 of the RTI Act says that the public information officer may be imposed with a penalty, not the first appellate authority. Last time, your lordship wanted to know whether the information has been supplied to respondent number 2 or not. As per my information, the information has been supplied, and a wrong order has been passed by the state information officer at annexure at annexure 6.
So which power has been exercised? Section 20.
Section 20.
Where is 20,000?
Right to Information Act, section 20.
Yes.
May I read?
No, where is 20,000? Sir, 25,000. So you are the appellate authority.
I am first appellate authority.
First appellate authority.
Wrongly treating me as the information officer, the penalty has been imposed wrongly on me.
And what is the order passed by the single judge?
The order of the State Information Commission is at page number 54, annexure 6. Paragraph 11.
No, where is the order of the single judge? Which annexation?
61.
61.
Annexure 7, my lord, 58.
Who is for the other side?
I am from for respondent to private party.
Mr. Das, are you not appearing?
State Information Commission, my lord, kindly remember in the last occasions, in fact, the opposite party respondent also wanted to issue notice. In fact, the last order was that.
I am entering my appearance.
So he has already entered appearance.
My lord.
He has entered appearance.
Has entered appearance.
Yes,
You are appearing.
yes, my lord.
So how do you justify how the appellate authority can be imposed punishment?
Yes, sir, I will convince my lord. It is admitted fact that at that time she was the first appellate authority, but she has not appointed the PIO. That's why in this way she obstruct to get information under RTA Act. My lord.
Mr. Please try to understand.
Yes, my lord.
The penal provisions are to be read strictly.
Yes.
So where is the penal provision?
Yes, in section 20.
Section 20 will not apply.
No, I will convince my lord.
Where is the question of them?
No, my lord. I will direct to what is the duty of section 5(1), my lord? C.
Duty forget. Come to penalty.
Yes, penalty. My lord, section 5. 5
is penalty.
No, I will convince you what is written. How who obstruct to get information under RTA will be treated as public information officer. Section 5(5). Can I read, madam?
That is also different.
No, my lord, that is the objective of the RTA because otherwise, when as an applicant, one should address to PIO.
Please try to understand this. Under the scheme of the Act, Section 20 provides for penalty.
Yes.
That penalty is to be imposed on the PIO. All right. So, but if PIO wants someone else's assistance and he does not extend that assistance, he will also be treated to be a PIO for the purpose of the Act.
My lord.
Not the appellate authority.
No, but so when an application is received by a public authority, school is here a public authority. If PIO, without referring that application to the first appellate authority, if head of the public authority is first appellate authority, if he received the letter and did not forward it to PIO,
we are not convinced.
my lord, then go to the 2H, my lord, for public authority. It is not a dispute fact that a school is a public authority.
To 8.
2H.
H.
My lord.
Yes.
Public authority means any authority or body or institution of self-government established or
Why are you referring to that?
That, my lord, as a head of the institution, the appellant.
The very simple question is,
my lord,
under Section 20, only public information officer or central public information officer can be penalized.
My lord.
One is.
Whenever first appellate authority refuse to accept that letter, that addressed to PIO, then he or she will be treated as a PIO.
My lord, 6.3. Section 6.3.
You will make us read whole the entire act.
Because I prepared that.
All right, we are ready.
Yes, right. No, as per convenience of the court, my lord.
Please. We are also trying to understand.
Yes, my lord. Otherwise, the purpose of the RT Act will not be fulfilled.
Purpose of the RTI can be frustrated by if there
Yes,
is
my lord,
any
because
provision to frustrate that can be.
Otherwise, only first appellate authority refuse all the letter and he will not be penalized. That's why that obstruction clause is there.
Yes.
And in 6.3, where an application is made to a public authority requesting for an information which is held by another public authority or the subject matter of which is more closely connected with the function of another public authority, the public authority to which such application is made shall
Again,
transport
Sir
the
Counsel, this is duty. This is the duty for disobedience of this. Appropriate action can be taken, but penalty cannot be imposed.
Now, my lord, as a public authority, he has the duty to appoint a PIO. He doesn't do that. And whenever she received a RT application, she should have appointed the PIO and forward that letter to the PIO. Instead of that, she rejected and didn't receive the letter. That's why.
We have understood. Can we complete the order?
My
First case. Tomorrow, first case. Yes, Mr. Advocate General, are you waiting for?
No.
Will I?